The time is now 4:19. We call this meeting to order of the Sunshine Ordinance Task Force. Clerk, would you call the roll?
Item number 1, call to order, roll call on agenda changes. Matthew Kate? Present. Matthew Kate, present. Lila Hood, not present. Josh Wolf?
Present.
Josh Wolf, present. Rishi Chopra, not present. Luam Tesfaye, not present. Bruce Wolf, not present. Rodman Martin?
Present.
Rodman Martin, present. Frank Canada?
Present.
Frank Canada, present. Chris Highland, absent. Matthew Yankee?
Present.
Matthew Yankee, present. Fiona Hinsey?
Present.
Fiona Hinsey, present. We have a quorum. Item number 2.
All right, go ahead and call the next item.
Were there any agenda changes for anybody? None?
Yes, thanks for reminding us.
Okay. Item number 2, approval of the minutes from the Sunshine Task Force, August 7, 2019 meeting. Anybody have any changes?
I have a couple.
Of course.
First one on the bottom of page 4, I believe the motion was that did not violate, and you have it as violated. It was Member Kate's motion. Maybe you could verify that.
Item number 4, you said?
Bottom of page 4. It was item number 4, bottom of page 4.
That was item number 6 at the bottom of page 4.
Item number 4.
Item number 4 at the bottom.
The motion that's at the bottom of page 4 is, the motion was did not violate, not violated.
Yeah, the motion failed.
No, the motion was,
But the motion was to find no violation.
yes.
And that was for file number 19043?
Yep.
Okay. Any other changes?
Yeah, just one little one, just bottom of page 13. The count on absent is, you have 4, it's actually 3.
What item number?
It's, yeah, 15, bottom of page, yeah, item number 15, bottom of page 13.
Item number 15. The absent number should be 3. Is
Right.
that what you're saying? Yeah.
Yeah, exactly, you got it. That's it.
Okay. Can fix that.
I move to approve them then.
Second.
I'll take the roll. Member Martin?
Aye.
Member Martin, aye. Public, I apologize.
Is there any public comment on the motion? Seeing none, can we go ahead and take that by acclamation? Yes. All right, that passes by acclamation. If you could call the next item, please.
Item number 3, file number 19010, hearing to consider action to close Sunshine complaints due to inactivity and noncompliance with the Sunshine Task Force complaint procedures for the following files. Do you want me to read them all?
I think we can just acknowledge them and are written in the record. Is there any concerns about that? Great. So it looks like we have pretty much all complaints filed by Anne Trabeau. Is there any conversation or a motion at this point?
Just for the record, we probably would like to give you a brief summary of what has happened in the past year or so.
That sounds great.
Basically, Ms. Trabeau has filed several complaints over the years. They have been continued, many of them have been continued on many occasions for various reasons, illness, out of state, and so forth. Recently, her email address stopped working, and there was, upon contacting her via telephone, when she called us, she refused to provide us a reliable means of contact to let her know. However, we did receive a call within the last day or two. She acknowledged that she knew that we were going to close it, and she did not object to that.
Great. Thank you.
I made notes of that telephone conversation that I'm passing out right now.
All right. And there are copies available for the public on the table, or?
No, we can put, it's not part of the agenda because I got the phone call yesterday, so.
Sure, if we can just make one copy at least available for the public to review.
There's several here. There you go.
Are there any questions on Cheryl's memo?
Of the 4, I'm seeing that Mr. Bowe said she had 4 complaints that she cared about. Did she identify them, or do you know
No,
if
she
they're on?
didn't. She didn't. I told her that, we intended upon closing her complaints, but if she wanted to reopen in the future, she could. And I know that one of them in particular, she was very interested in, but she mentioned 4 yesterday, so it's up to her.
Does anyone feel called to make a motion on this?
Sure, I move that we close all these complaints for the reasons stated.
Excellent. And there's a second. Great. Any public comment on this? Seeing none?
And Matthew, you second? Okay.
Yes.
Take the roll.
Yes, go ahead.
Member Yankee?
Aye.
Member Yankee, aye. Member Martin?
Aye.
Member Martin, aye. Member Wolf?
Aye.
Member Wolf, aye. Member Tesfaye, absent. Member LaHood?
Aye.
Member LaHood, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Member Highland, absent. Chair Wolf, absent. 1, 2.
Great, thank you.
And me.
Oh, and me.
Oh,
Oh, I didn't, I asked, sorry.
No.
Frank Canada?
Aye.
Aye.
And me as well.
But you made the motion.
And
Yeah.
but
And,
Yeah.
and member
Yeah.
Kate also. Cheryl?
Yeah, Member Kate. I thought I called your name. I'm sorry.
That's all right.
great. Everyone comfortable with that roll call vote? Awesome. All right, next item, please.
Item number 4, file number 17101, complaint filed by Randy Sinke against the Arts Commission for allegedly violating Administrative Code Section 6725 by failing to respond to an immediate disclosure request in a timely and/or complete manner.
Great. And is Mr. Sinke here? All right. Have we heard from Mr. Sinke about
About his complaints?
about whether he intended to come today?
I never heard a word. There are 2 matters here on the calendar involving Randy Sinke, and I never got word. I mean, Randy Sinke got notice of the appearance and the agenda packet, and I emailed that out Friday, so I haven't heard anything.
Great. And is the Arts Commission here?
Arts Commission was notified of the hearing, too.
Did the Arts Commission respond about whether they intended to show?
No.
All right. So I think there's a couple ways we can handle this. I'm curious if anyone has any thoughts.
Well, I was reading through this, but I don't remember. Has Mr. Sinke ever appeared at any of the meetings? Because these are from a while ago, right? And
Yes, Mr. Sinke, and as long as I've been here, has never appeared. There was a matter that was handled by Ann Trabeau, said that she could speak for Mr. Sinke. I haven't heard.
Victor, do you know if he had been here before while you were?
Mr. Sinke, as far as I know, has never made an appearance. However, we have made additional attempts to contact Mr. Sinke, and we have not received a response regarding appearance. Because they were so old, we did try to reach out to him, and we haven't received a response. Pursuant to our complaint procedures, as we have not been informed that Mr. Sinke would not appear today, our procedures state that we should close the files, inform the parties that we have closed it, and they have a certain amount of time to ask that we reopen it if they object to the closing. That is our standard.
So that all sounds fine. I'm curious whether or not the fact that the Arts Commission also didn't show up should be memorialized in some way.
Yeah, I mean, I think the motion could say notify both parties of the closure for failure to, didn't appear. They can reopen.
Is it possible that the complainant contacted the respondent, or do we think that's unlikely?
I mean,
I would not want to.
even if the
Yes.
even if the complainant resolved it informally with the respondent, it
That doesn't
seems to
follow our
me that the
procedure.
respondent should still reply we aren't coming because we resolved it, which is why I'm kind of open to the idea of exploring a violation for their non-appearance at the hearing, but I don't know whether anyone else is.
I think these are so old, and I don't know the history of it, but if the Arts Commission has appeared every time they were scheduled and Mr. Zinke's never appeared, and it's the only items on the agenda for the Arts Commission, I think, then I just would let it pass and close these, both of them out. We'll do one, do one at a time since they're
Sure.
separate items.
Is that the general consensus? All right. Is there a motion?
Sure, I move to close this item.
Is there a second?
Second.
Seconded by Kate. Any public comments?
And we will just note that we will inform the parties that has been closed and give them an opportunity to reopen if they so request.
Sounds great.
Is this for both matters?
Let's
Item
do this
number-
one at a time for
Okay.
cleanliness. Clerk, would you call the roll?
Member Yankee?
Aye.
Member Yankee, aye. Member Martin?
Aye.
Member Martin, aye. Member Kanata?
Aye.
Member Kanata, aye. Member Kate?
Aye.
Member Kate, aye. Member Wolf?
Aye.
Member Wolf, aye. Member Tesfaye, absent. Member LaHood?
Aye.
Member LaHood, aye. Member Hensy?
Aye.
Member Hensy, aye. Member Highland, absent. Member Chair Wolf, absent.
All right. Would you go ahead and call the next item, please?
Item number 5, file number 18018, complaint filed by Randy Sinke against the Arts Commission for allegedly violating Administrative Code Section 67.14 by failing to make audio recordings available online within 72 hours.
Are the previous motion parties prepared to make the same motion?
Yes.
Yes.
All right. Any public comment? Seeing none, call the roll.
Member Kanata?
Aye.
Member Kanata, aye. Member Kate?
Aye.
Member Kate, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Martin?
Aye.
Member Martin, aye. Member Wolf?
Aye.
Member Wolf, aye. Member Tesfaye, absent. Member LaHood?
Aye.
Member LaHood, aye. Member Hensy?
Aye.
Member Hensy, aye. Member Highland, absent. Chair Wolf, absent.
All right. Next item, please.
Item number 6, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the task force jurisdiction, but not on today's agenda.
I thought public comment has to be at 5 or
5.
I think the next couple of items are.
It's not listed at this point as that. Right.
Oh, okay.
In the past, it has been. For whatever reason, it's not. Is there anyone that would like to make a public comment at this time?
Members of the task force, Ray Hartz, Director, San Francisco Open Government. I am a little concerned about the 5 o'clock because I know some people do plan, if they want to speak to the task force, to come at 5 so that they know that there's not a long wait. I was going to ask, was that a change?
You have something on the,
Yes, please. I'm sorry. Oh, there we go. Used up my time doing that. Sorry.
I apologize, go ahead.
That's right. For over a decade now, I have been going after the San Francisco Public Library regarding their financial arrangements with this group called the Friends of the San Francisco Public Library. And I have many times to the Library Commission made clear that the public records indicated to me that very little of the money that actually is raised by the Friends each year goes to the library. And this chart is actually from public records, either on the library's public website or the Friends website, basically showing that 10% or less of what they raise each year, even though they raise millions each year, actually goes to the library. And that's only if they give the full amount authorized by the Board of Supervisors. Under the law, the library can't accept these gifts from them unless it's authorized by an accept and expend grant by the Board of Supervisors, which it is each year. And if you look at the third column on here, it's become pretty static now, $400,000 a year. It doesn't matter how much they raise each year. The friends give the library $400,000, which in every case that we have all the documentation for those 3 given years, it's 10% or less, which means 90% of the money that you give to the friends, nobody can answer for. And yet on a public website, on the library's website, there is a link to this group, and it says support the library. You click on it and it takes you to this group. Now, I've heard of veterans, supposedly funding and leukemia funding and things like that, and people get really upset when they find out that very little of the money that they're giving goes to the purpose which was put out there to the public. And yet here we have a city agency committing what I consider to be fraud, basically telling people if you want to support the library, give to this group, but failing to tell them in any way, shape, manner, or form that the group isn't going to give us anything greater than 10%. In fact, one year it was as low as 6%.
Thank you. Anyone else wanting to participate in public comment at this time? Seeing none, go ahead and call the next item. Oh, and thank you for your concerns about the 4:30 thing. We'll figure out through the chair whether...
Item number 7, file number 17134, complaint filed by Thomas Bussey against the San Francisco Public Utilities Commission for allegedly violating Administrative Code Section 6721, 6724GI, and 6727 by failing to respond to a public records request in a timely and or complete manner, and against the Office of the City Attorney for allegedly violating Administrative Code Section 6721I for acting as legal counsel for denying access to public record.
And is the complainant here? I'm sorry.
The respondent is present. The complainant is not present.
Thank you.
And I just want to clarify that this item was originally filed against both the Public Utilities Commission and the Office of the City Attorney. However, the item was split into 2 different files, so this item should only be against the Public Utilities Commission, and the next file, 18013, would be against the City Attorney. That was done by the committee at that time. They felt that it was separate issues, and they split the file into 2 separate files.
Thank you. As we discussed earlier, our standard procedure when the complainant isn't here as to dispose of it, but I'm curious whether anyone from the committee that heard this the first time has any quick summary before we move forward without the complainant present.
I was not on the complaint committee back then. I don't know if anyone.
I mean, I was, but I wasn't chair taking the notes, and the name does sound familiar, but frankly, it's so old that I don't remember much of it. But Member Tesfa was the chair at the time, and she's not here for another few minutes. So yeah.
All right. Did we hear from the complainant about their intent to appear today?
I didn't hear anything.
Okay. And let's see. This one is Public Utilities, right?
Yes.
Does Public Utilities have anything to say before we likely dispose of this, which would allow it to be reopened by the complainant in the future?
Good afternoon, task force members. My name is Cassini Yip with SFPUC. And if it's helpful in regards to timeliness and completeness of our response, I would be happy to walk you through the timeline to give a summary of what transpired.
I would like that. I would like the timeline, and also I would like to know if Mr. Busey got any of his data, all of his data.
Sure, would be happy to do that.
Great. That sounds great.
Okay. So on October 6, 2017, Mr. Busey asked for all documents in the possession of the SFPUC matching the description of an emergency action plan described in Section 8589.5 of the Government Code. And, quote, my request includes emergency action plans of SFPUC facilities as well as other California facilities that the SFPUC may have on file for reference, consultation, etc., including email attachments, etc., but are not actually emergency action plans created by the SFPUC, especially plans of the SWP and Department of Water Resources. So I highlight this portion of this request that came through our public records. There were several others, but for purposes of complaint number 17134, this was the portion that we're here to talk about today. Due to the voluminous nature of the request, we requested an extension, and that was invoked. And we provided, the SFPUC then responded by saying that the SFPUC declines to disclose any emergency action plans pursuant to California Government Code Section 8589.5E. Further, it would be a security risk to disclose these plans. However, under SB 92, inundation maps will be made publicly available by the California State Department of Water Resources after they're approved by the department. See California Water Code 6161. And then we said SFPUC is in the process of updating its inundation maps and plans to submit them to the department for approval in 2018. So that happened in October 30th of 2017. On December 21st, 2017, Dennis Herrera, City Attorney, sent a letter to the Sunshine Ordinance Task Force urging the task force to dismiss Mr. Busey's complaint. And I have a copy of that letter, if that would be helpful.
The record already, Cheryl? You know?
I put matters that were in the record that I received.
Okay. Has this letter been sent in previously? Okay.
Yes,
so
it has been.
Okay.
And then following that time, fast forward to April 17th, 2018, based on legal counsel from the City Attorney's Office, the SFPUC then sent two letters on the same date, April 17th, 2018, one to honorable members of the Sunshine Ordinance Task Force and one to Mr. Busey. And the purpose of the letters were to provide an update regarding this complaint and pertaining to the PUC's decision to withhold from disclosure emergency action plans. And we said that in the wake of the recent incident at Moccasin Dam, at the March 27, 2018 meeting of Complaints Committee of the Sunshine Ordinance Task Force, we asked for and were granted a continuance to review our emergency action plans to determine whether or not to release redacted copies to the public. On March 29, 2018, we provided to Mr. Busey and the Sunshine Task Force a redacted version of the emergency action plan for Moccasin Dam. That should also be in the record. And we've now completed a review of the remaining EAPs, emergency action plans, in our possession. And at that time, we said we're producing redacted versions to both Mr. Busey and to the Sunshine Task Force to be included in the record, which we did. And we said that now that the SFPC has provided Mr. Busey with the redacted versions of the records he requested, we hope we've satisfied the request. And he will either withdraw his complaint or the Sunshine Task Force will dismiss it. That was April 17th of 2018. So Mr. Busey's, the letter that the PUC generated to Mr. Busey reflects or mirrors the content of what was sent to the task force.
Great.
And so the responsive documents included emergency action plans that have been redacted for a number of different reservoirs that were requested. Calaveras, Cherry, Eleanor, LCS, O'Shaughnessy, Pilarcitos, Pre-San Antonio Summit, Sunset, Sunset Sutro, and Turner.
Great. So that's the amount of time we have for your intro. But just to make sure I understand, it sounds like at this point the complainant has received documents, whether they have, been censored or not, of all of the requested information he received as far as you're concerned. Is that what I'm hearing?
Yes.
All right. Thank you.
Why did it take 7 months? I understand that initially you said for security reasons we can't release these, and then you decided that releasing them, some of them redacted, was a way to go, and it seems like you've provided reasons for the redactions. But still, it took 7 months. Any specific reason for that?
I was not here, part of the PUC. I do know and understand that there was counsel from City Attorney's Office and advice from City Attorney's Office at that time. And that's what I do know.
And one additional question. In those 7 months, were there some documents provided on a rolling basis, or did you wait did you wait the 7 months and just give them all the documents at the end?
My records show that we aggregated and released things in one or two file shares. These are very large documents because it took some time to do the redaction, as you might imagine, with each emergency action plan.
Okay, but so if there were two file shares, but did those two file shares happen at the same time, or was one like in 4 months, one in 7?
I would have to go back and see. They were two separate file shares. It could have been limited by the size,
Okay.
but to be exact, I'd have to go and check.
Okay, thank you.
Great. Thanks. Is there a motion for this matter?
I motion to close the file.
Is there a second?
I second.
All right. Is there any public comment on that motion? And Cheryl, you got the motioner in the second? Great.
Hi, Ray Hartz, Director, San Francisco Open Government. I am a little concerned about the 7-month time delay, and it's really not clear whether they provided anything on a rolling basis, as the respondent has said she has no idea whether it was just one fell swoop or two separate things. So I would say there, at a minimum, is a violation for timeliness and failing to produce the records on a rolling basis, which is required by the law. I'm very careful when I make my public records request to include that as part of the request, so that if they do one of these things where they just drag it on for months and months and months and months and months, I can say, I specifically asked for this on a rolling basis. So I do believe there is a violation for timeliness, and whether you wanted to consider a second violation for failing to provide on a rolling basis, I really do think that gives a little bit of an impetus to organizations to reply in accordance with the law, because that's what the law requires.
Thank you, Mr. Hartz. I definitely think that if we had the complainant here, we might have worked through this differently, but our standard procedure is what we're moving forward with. Is there...
I believe the respondent would like to clarify the rolling basis issue.
Go ahead.
Thank you. In fact, 13 emails with responsive documents were sent between March 8th and March 19th, 2018, that involved not just inundation maps and emergency action plans for Moccasin, as well as a notification flowchart, because the original request from Mr. Bussey did not only involve the request for emergency action plan related items, but in fact involved, if I may outline the other items, all contracts, declaration of policies or similar agreements establishing favorable rate of water, power, sewer service provided to SF Community College District, as well as another item, any request for public records regarding above stated agreements or correspondence concerning it from current Vice Chancellor of Finance and Administration, David Martin, or his assistant from the Management Assistance Team. About utility rates. I'm just summarizing.
Hey, there's a motion to close it, so we can.
She's reading it into the record. Well, she's got 40 seconds left on her
There were multiple.
clock.
There were multiple requests, and we to the best of our ability, endeavored to provide and fulfill those multiple requests, including of which the emergency action plans were not the only item. And so during that time period, we did provide information on a rolling basis.
Great, thank you. That'll be recorded into the audio recording. Any other public comment? Seeing none, go ahead and call the roll.
Member Martin?
Aye.
Member Martin, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Wolf?
Aye.
Wolf, aye. Member Tesfaye, absent. Member Kanata?
Aye.
Member Kanata, aye. Member Kate? Member Kate, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Member Highland, absent.
I can do it. But
Is
I
it
get
absent
so-
still?
I got so used to you having it right there for me.
The motion passed.
All right, at 4:49, we are recognizing that Chair Wolf is here and will be returning shortly, I guess is how we'll do that. Go ahead and call the next item.
Item number 8, file number 18013, complaint filed by Thomas Bussey against the Office of the City Attorney for allegedly violating Administrative Code Section 6721I for acting as legal counsel to deny access to a public record.
All right, and is the city attorney here? Great. If the representative from the city attorney would like to share their side of this, otherwise we will move forward with possibly our standard procedure unless someone calls for otherwise.
Good evening, task force members. John Cote, Communications Director for the City Attorney's Office. I will be very brief. I would simply point you to our written responses to this body in this matter, including on December 21st, 2017, which is page 290 of your packet, I believe, January 23rd of 2018, page 288 of your packet, and July 25th of 2018 on page 408 of your packet. And based on those, I would ask that you dismiss this complaint. And I'm happy to answer any questions you may have.
Members, any questions? Is anyone inclined to make a motion at this point in time?
A motion to close the file.
Is there a second?
I'll second.
Great. Is there any public comment?
Members of the task force, Ray Hartz, excuse me, Director, San Francisco Open Government. I'm rather concerned about this for the simple fact that I've read through the memos, and they're very similar to my case that we'll be hearing next. One of the things that the city attorney's office seems to keep asserting is that we're saying they can't give advice. And I've never said at least that they can't give advice. But what I am questioning is when their advice always ends up with the result being public records are withheld, and they're not explained as to what the reason or basis for the withholding is. That's questionable. And very frankly, I think it's rather disingenuous of the city attorney's office to hide behind attorney-client privilege and, say, well, we can't tell you what we advise them. We can't tell you whether they followed our advice. We can't tell you anything. We're just basically saying they don't have to produce the documents. And I've gone through the last 10, 12 years getting that same response every single time from the city attorney's office. Mr. Hartz is saying that we can't advise, yes. But I also recognize there's a conflict of interest. Yes, they are advisors to the various city departments, but they are also advisors and supposed to look out for the benefit of the citizens. But they always take the side of the city agency in withholding the records and never take the side of the city of a citizen asking for the records. And at some point in time, I think that has to be considered in the reality of the world. If the bottom line is you're giving them advice, we don't know what the advice is, but the result is they're withholding documents, then at some point the question becomes, are they doing it on your advice? I've mentioned this before with Sue Blackman on the Library Commission. She has come in every one of the 11 determinations that I have received and said, we're acting on the advice of the city's attorney's office. Who says? There's nothing there from the city attorney saying what the advice was. There's nothing there saying specifically by her what the advice was. She could come in here and say, I'm following the city's attorney advice, and the assumption and her premise is, oh, well, I followed one point that the city attorney advised us on and ignored the rest of it. So at some point, this really becomes a question. Who does the city attorney work for, and whose interest are they answering when they deny public records? In this particular case, I have a real hard problem. It's like you sending things over to the Ethics Commission, and every single thing you forwarded to the Ethics Commission, they have failed to deal with. They either dismiss it without a hearing, or they do even worse, which is have a hearing and say, you got it wrong. So basically what I'm saying is the city's attorney's office is not dealing in good faith. They are hiding from the public documents. They are allowing agencies to hide documents, and they are not complying with the law and saying we're withholding this document. They're simply saying, you know, and then they let the agency go out and claim they're acting on their advice.
Thank you, Mr. Hartz. Is there any other public comment?
Through the chair.
Go ahead.
I have an issue with closing this if by closing it, we're making a decision on the facts of the case.
So we are not making a decision on the facts of the case. In essence, we are closing without prejudice, which means that the complainant can refile. It's essentially a situation where our process, with rare exception, requires the complainant to participate in the hearing. Without the complainant in the hearing, we are disinclined as a standard procedure to move forward, and that's how.
Okay, that's fine then, as long as we're not making a decision on the validity of the claim.
I have just a clarification. Am I walking in here in the middle of an existing? What was the motion that you made before?
To close it. The complainant's not here.
And has not been responsive.
So that was for a previous case?
For this one.
There's two cases with two different agencies by the same complainant who wasn't here.
Okay. So this is for the second one?
Yes.
And is this was this continued at the task force? Did you go through the process of
the last time
the
this
hearing?
was heard was at the committee level, and it was referred to the
Here?
to the task force.
So did you start with the complainant and our regular process for hearing?
There is no complaint.
There's no complainant.
Not here.
He's not here. So why are you closing it?
Pursuant to our procedures, if the
complainant is
complainant
not here?
is not
Mr. Bussey
present,
is not here.
It's not
Okay.
right.
And I have not heard anything from him.
Okay. Oh, okay. I hear you on that. Okay.
So if this is still of concern to Mr. Bousset, he can file a new complaint, and we'll definitely move forward with hearing it. But unless there's some overriding reason to ignore or overcome our standard procedures, we have a motion on the table to follow those procedures.
But Mr. Bussey did show up at the committee.
This was back
Over
in
a year
early
ago.
2018.
Got it. Okay.
Based on the last case we heard, it sounds like he eventually received the records he was requesting, although in a redacted form, which may be part of the reason he chose not to attend, although we obviously don't know.
Okay. So, this is against the PUC? No.
This is against the city attorney?
Got it.
This is the second one,
So,
18.
in here, from the complaint committee, I just want to note that Chair testified, because what's important about this is, there was a case. It was, what was it at Ethics? Grossman versus St. Croix. And that was about Mr. Grossman trying to receive communications between the two parties between the respondent and the city attorney, phone calls or what have you with regard to that, and was more or less trying to cite 6721I. This case is a little bit different, okay? Here we're talking about the city attorney providing advice regarding how to implement the Sunshine Ordinance. So I think it's important that we read 6721I because that's what is applied to this.
I was going to read that if we were going to close this with a decision. My feeling is we can read it for the next case because it's an identical case.
Okay, that's fine. I'm happy to do that.
I agree with you, though. 6721I is key.
So if this is purely, all I'm saying is that if this is purely procedural to close the case, that's fine. But I think, yes, I agree that the petitioner had, make that part of the record.
Yeah, I mean, when we made the standard procedure to close out cases, if the complainant wasn't here, I was not necessarily in favor of that plan, but unless there's an overarching reason to step in, now that we have that procedure, I think that's where I stand. But at this point, we have a motion and a second, so if you want to... Is there... Yeah, we don't need to do a second public comment. Go ahead and call the roll.
Member Martin?
Aye.
Member Martin, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Wolf?
Aye.
Member Wolf, aye. Chair testify absent. Member Kanata?
Aye.
Member Kanata, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Kate? Aye. Member Kate, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Member Highland, absent. Chair Wolf?
Aye.
Chair Wolf, aye. The motion passes.
And just for our administrator, because I'm not acting as chair today, facilitating the meeting, if you can call Vice Chair Wolf at last in case he needs to break a tie, because he's the one with the gavel.
Okay, that's fine.
Thank you for that.
May I suggest that you call for public comment again, as it is now 5 o'clock, and officially close general public comment?
That sounds like a great idea. I was going to ask if we could legally do that. It's now 5 o'clock. Is there anyone who hasn't previously spoken in public comment that would like to do so at this time? Seeing none, is there a motion to close public comment? Do we need a motion to close it? Okay, public comment is now closed.
Unless somebody wants to appeal your decision to close it.
Okay, public comment is closed unless I hear from one of my colleagues that really wants to wait for another member of the public to step up. All right, if you could call the next item, please.
Item number 9, file number 17086, complaint filed by Ray Hartz against Dennis Herrera and Bradley Rusi, Office of the City Attorney, for allegedly violating Administrative Code Section 6721I by acting as legal counsel for city employees or any person having custody of public records for the purpose of denying access to the public.
Great, thank you. If we can get some time on the clock for Mr. Hartz. The floor is yours.
Members of the task force, I'm really not sure how to proceed with this because it is, raising an issue that was covered at the last task force meeting, and that is whether the Friends of the San Francisco Public Library, under the terms of the ordinance, should be required to comply with not just that one particular paragraph in the ordinance, or whether they, as the ordinance clearly reads, should be made to comply with the entire ordinance. Now, one of the things that I will say here is that, again, as I previously said, the city attorney's office seems determined to always take the side of the agency in withholding public records. Throughout the whole process of me coming here and saying to this task force, this group raises money, and under the terms of the ordinance, they are required to divulge where they get the money from at a minimum, but it does say the whole ordinance. And you have agreed with that, and they have finally met that, and that's where I got the public records that I did during general public comment from the Friends. Now, one of the things I will say about the memo is the point that, again, we have a conflict of interest. I'm the deputy city attorney advising the Library Commission. I know from our discussions that the Library Commission wants to withhold or does not want to put the Friends in the position of having to disclose information. So I write a memo to the library telling them all these hypothetical things that a judge might do or might not do. Well, as we all know, the law can be turned around on the
Dime.
Yes, thank you. And I would imagine that there is probably any number of good attorneys who could go through in the law and find a whole bunch of reasons that would be just contradictory to this, in which a judge would say, no, you do need to disclose that. As I've said to you on many occasions, this group raises millions of dollars a year, gives 10% or less of that money to the library, and that's if they fully fund the accept and expend authorization from the Board of Supervisors, and the other 90% or better of the money is unaccounted for. Now, I think it's in the public interest to know where that money goes, especially since the public is being extorted, exhorted by the library to contribute to this group. And yet, for the last 10 years, the library and the Library Commission have done nothing but refuse and say, oh, no, we don't have to have any records about the Friends. The Friends don't have to provide any records. I have never heard of any public entity authorizing a group of outside private citizens to raise money in the name of that entity and be accountable to no one. They don't report to anyone. They aren't asked about anything, and I've raised these issues over and over again at the Library Commission meeting, and it just goes in one ear and out the other. Now, I know why that is, because they are all appointed by the mayor, as is the city librarian. And this is a big scam. Basically, if you give $10,000 to the Friends, thinking you're supporting the library, the Friends will be lucky if they see 1,000 of that. The other 9,000 is basically going, as far as I can tell, for fundraising. And that makes it a fraud, because what's being put out to the public is that give to this group to support the library. And yet, when I originally started doing these public inquiries, my first one dragged out for 2 full years. I had a copy of the Memorandum of Understanding between the Friends and the library, and the Friends were required to report on an annual basis how much money they raised. And the city librarian, former city librarian, dragged that out for 2 years because he did not want to publicly acknowledge that they had never asked them to provide that information at any time. I estimate right now that we're somewhere in the range of upwards of $90 million that has passed through the hands of this group, and maybe 9 or 10 million, 3 to 5 million of it actually made it to the library. Now, if you or I started a charity and raised money and told people we were raising it for whatever purpose, and somebody found out that that was the case with us, we'd be in jail. But it seems like if the city wants to run a scam, it's okay.
Is there anyone speaking on behalf of the complainant today? What?
Oh, sorry.
Seeing no one, respondent, you have an opportunity to respond or make a case, and then you'll respond.
Good evening again, task force members. John Cote with the City Attorney's Office. I would refer you to our written responses in this matter. I trust that you've read them. For reference, they're on page 408 of your packet and 453 of your packet. I'll make a couple of brief points. The first is that the issue that is before you today is not about the Friends of the Library and funding. It's a very narrow issue, which is an allegation of a violation of the Sunshine Ordinance, and specifically it's section 67.21I, which speaks to whether or not our office acted as legal counsel for any city employee or any person having custody of any public record for purposes of denying access to the public. So the memo that we prepared in this matter was not even about that issue. So our advice letter did not address denial of access to the public, denial of access to a public record. It addressed whether or not, as a condition of a third-party gift to the city, the donor entity was required to comply with the entirety of the Sunshine Ordinance. Separately, I would just simply point out that there is no violation here. There can be no violation when a deputy city attorney provides legal advice to a department or a commission as part of this office's charter-mandated role to act as legal counsel for the city. The deputy city attorney in this case was doing his job under the charter, and the charter safeguards, without qualifications, the right of the city to receive legal advice from the city attorney's office. Now, to the extent that there is any conflict between the Sunshine Ordinance and the city charter, as we laid out in our written responses, the city charter supersedes the ordinance. Now, that's not simply the professional legal opinion of attorneys in our office. That is the determination of the Court of Appeals in a published decision that is binding precedent. That is specifically the St. Croix case. So with that, I will answer any questions you may have.
Thank you. Is there anyone speaking on behalf of the respondent? Seeing none. Any thoughts, questions?
I have. I think it's worth noting, as I was going to do before, is I think it's worth noting to read into the record 6721I. I think that kind of sets the kind of the subject matter of where we are. As noted, the San Francisco City Attorney's Office shall act to protect and secure the rights of the people of San Francisco to access public information and public meetings, and shall not act as legal counsel for any city employee or any person having custody of any public record for purposes of denying access to the public. The city attorney may publish legal opinions in response to a request from any person as to whether a record or information is public. All communications with the city attorney's office with regards to this ordinance, including petitions, requests for opinion, and opinions, shall be public records. Now, as DCA Cote had claimed, that the charter under section 6102 supersedes the ordinance. But the ordinance has not been amended to wipe that out, if it does in fact supersede it. And that would be normal course of action, and that case has been, sitting there unchallenged for a number of years now. So I imagine 6721I then clearly is still in effect. Now, a court may say that it supersedes it. I haven't finished reading through Grossman versus St. Croix. It's actually St. Croix versus the Superior Court, I think, gave the, because there was an appeal in there that is actually where the decision was actually finalized. But I think what's interesting here is reading the charter. And under the charter for the city attorney, in its opening statement, says the city attorney shall represent the city and county in legal proceedings with respect to which it has an interest. Legal proceedings. The question is the Sunshine Task Force and this proceeding actually a legal proceeding? What is the definition of legal? And from my research and my questions to third-party attorneys, that means in a court of law. That's what that means. We're an administrative body. It's not clear, even in the ordinance, that we are holding legal proceedings, and legal proceedings would actually have some, enforcement effect.
So I think we're actually talking about before us, though, because the request for this document is before the complaint came before the Sunshine Task Force. So whether we constitute a legal matter, it hadn't entered our dominion when Mr. Hartz made the request for the documents, which catalyzed the discussion. It's before it reached us. It's not a Sunshine matter. It's a public records matter that is not even entered this quasi-judicial territory yet.
Well, but his complaint is about receiving that information.
But the document, the memo that describes whether or not these documents are public, precedes a complaint into the Sunshine Task Force. So it's even if you want to say that this becomes a legal entity because we're a quasi-judicial entity, at the point that the city attorney opines on whether or not a document is legal or not is before it gets to us.
Right. Okay. So I'm not following you here. The respondent is his argument is that under first of all under the city charter, they have a right to represent whoever in city government, and that automatically supersedes. And then on top of that is the St. Croix case, Grossman versus St. Croix case. So the question here is whether that information that Mr. Hartz is requesting should be released or not. And if they're standing behind a firewall saying we have the right to represent in this legal proceeding here, not to
Is the question the release of documents or whether the city attorney violated 6721I?
Well, it's acting as legal counsel for city employees for any person having custody of public records.
Right, but there's two things here. There's the memo that the city attorney drafted, which 6721 would make public. Mr. Hartz, can you... do you have a copy of the memo that the city attorney opined about whether or not these documents would be public?
Yes, and that's what I'm saying, is that his opinion basically is giving the authority to the Library Commission to withhold the documents.
Right, but they didn't withhold the legal opinion. They did provide the legal opinion to you when you requested it.
Not originally, no. I had to file a complaint to get it.
But that's not what this case is about.
No, this is about, again, what we talked about the last task force meeting, which is their interpretation is so restrictive of 6721, saying, oh, it only means you have the Friends of the Library have to comply with this particular paragraph. And I think that is something that the task force itself has agreed that needs to be discussed as to whether the actual wording, which is shall comply with this ordinance, is actually what the law means.
Great, thank you.
I hear you on that, and I agree. It's actually in the first section of 6721I that this applies to. I just wanted to make clear that we do have ongoing issues also with the revealing of communications and memorandums, and so that I didn't know that he had received the actual document. But continue. Yeah.
So it seems to me that this pertains to assessing whether or not the city attorney's advice constitutes a violation of 6721. And I'm curious if anyone feels confident in breaking that down for us.
Well, not confident, but I mean, the wording is the ordinance, not this section. And most places in the Sunshine Ordinance where they want to refer to a specific section, they refer to a specific section. So it seems to me that there's a subjective interpretation of what in the ordinance means. And in our discussions, I feel like it means the entire ordinance. So and that to me is a huge question, because if other departments hire not-for-profit groups to run to run major functions of their work, then that not-for-profit group can, in raising money and stuff, can say, we only have to we only have to adhere to this one section.
So I hear what you're saying. I'm kind of with where the city attorney's coming from on this, that the complaint itself, if we read what is written, and I understand in aggregate contextually where you're coming from, Mr. Hartz, but it seems like if we read the complaint, it's that the complaint is that the city attorney is acting as legal counsel in order to deny access to public records, which would be a violation of 6721. Is that a fair summary, Mr. Hartz? He's nodding his head yes. And so to me, this feels like a very subjective matter, because you can look at the role of the city attorney is to advise city departments on legal matters. This eventually could become a legal matter based on however they respond. The difference between providing objective legal information versus advising a department on minimizing the release of documents, to me, feels like a very thin line that I don't really have the legal expertise to thread. So I'm looking to the more lawyery folks to help fill that in for us.
So I'll jump in. And I would note that the charter, in addition to the representing in litigation proceedings, in section 6.103, paragraph 4, provides in the city charter that the city attorney is to, on request, provide advice or written opinion to any department head or officer, presumably on legal matters. But so they're required under the charter to provide legal advice.
I'm sorry, what was the?
It's paragraph 4 of 6.102.
Oh, 102. I thought you said 104.
And ultimately, I mean, to not drag you through, and I think the kind of legal analysis, my conclusion is that I think 6721I was a swing and a miss, and we almost will never be able to see if there's a violation, because you've got to basically see. I think that the key word there is for purposes of denying access. You can envision a scenario where someone says, please give me advice, wink, wink, or even explicitly, please give me advice to just, withhold this record. In that case, there'd be a much better argument for there being a violation of 6721I. But absent that, which will be very difficult to get because of the attorney-client privilege that St. Croix says is attaches to all these communications between the city attorney and the department, we're kind of left looking at an ordinance that we don't have a whole lot of ability to, I guess, adjudicate or apply without any further, evidence. I think we discussed the merits of this issue with the Friends of the Public Library. I think I probably disagree ultimately with the analysis of whether the record should have been produced, but that's not the same thing as saying just because we may think, or I may think, or anyone may think that the city attorney's office might have gotten it wrong, that doesn't necessarily mean that they were engaged for the purposes of denying access to the public. And I think that particular language, I think, is what's doing all the heavy lifting in paragraph I, especially in light of the St. Croix decision, the city charter requirement that the city attorney provide confidential legal advice. And that's kind of, I don't know if that helps or if that makes any sense at all, but that's kind of the way I see it.
I mean, that makes a lot of sense. Where I'm at is it seems like 6721I, or 6721 in general, is kind of not written in harmony with the way attorneys work.
Right.
And that an attorney is hired to represent a client. In this case, with the city attorney, it's really weird because the city attorney is representing an agency, but they're also still always representing the public because the public is always their boss. And so at the point that that there's an argument in both directions, is the city attorney supposed to argue in the way that benefits their first boss, in this case, the library, or their second boss, the people of San Francisco who have a right to access information? And 6721 attempts to draw a line there and say that they represent the public first in terms of information and the agency second, but it seems that the principles of the legal practice don't actually allow for that without creating a separate city attorney for each of these things that would represent the public, and you'd create two memos, but none of that exists in the law either.
Another thing that comes to mind is that we hear of the cases when there's a memo that that does not give the person requesting information what they want. Do we know how many instances there are where the city attorney says, yes, you should release that document? Does the person receiving the document say, oh, did the city attorney tell you to give me the document? No, of course they don't. So I question the assertion that they always say don't give the document.
I don't think I was trying to make that assertion.
No, I did not think that was your assertion, but it came up that they are that when an agency is saying, do we need to release this? I don't think the answer. You know what? I'm going to stop down that path.
Yeah, I mean, unfortunately, it seems that the St. Croix decision means that we couldn't actually get a copy of all those memos to analyze that, which just creates another black box to really navigate through this.
So I want to get back to kind of what the complaint is actually talking about. Did the city attorney actually give advice to help the library deny access to records that are enumerated in the Sunshine Ordinance? And it's pretty plain reading as to that. As far as receiving the information or not, that to me is somewhat secondary because we have the information. So if you look at starting on, what is it, page 458, that is the Bradley, from DCA Bradley Russi to Luis Herrera. The entire reason why it shouldn't be released. And it boils down to two things: that a court might find it ambiguous, and that if they were to release it, that it could cost the city a lot of money because donors wouldn't if they donate anything more than $100, their name would have to be released. Well, that happens in political campaigns. If you give a check for $100 or more, your name has to be published, has to be made public. That's what this more or less is also trying to do. And I think it's important to read Mr. DCA Russi's opinion, because his opinion is offering a lot of information that would lead to denying the release of the records. It's basically not giving any specific, there's a lot of references to a lot of courts, a lot of case law, okay? But for instance, on page 463, Roman numeral 3, construing the agreement requirement to apply to the a requirement to apply the entire Sunshine Ordinance could lead to unreasonable results. Well, but that's not the core of the case. The core of the case is, are they supposed to release the information or not? Not what the consequences are for doing that. That's not the crux of the case here.
But I going back to what I was saying that you seem to think was moving in the opposite direction, like the issue is, was the city attorney advising the library around the way that the library could meet their objectives in order to maximize funding and all this stuff, or were they advising them for the purpose of denying records? Because I think that at the end of the day, the outcome is to deny the records, but I think that any attorney can argue that the purpose of my argument, I wasn't asked to come up with the best way to deny records. I was asked to come up with the best way to maximize funds for the friends, protect our privacy, all of these concerns, that the end result is denying records, but whether the purpose was to deny records or not is, to me, where this entire thing hinges, and I don't really know how to navigate that.
If I could just bolster your point, if you read a very first paragraph of that citate, that what I referred to on page 463, it says where, quote, more than one statutory construction is arguably possible, the policy of the Supreme Court has long been to favor the construction that leads to the more reasonable result, unquote. That's just an interpretation of the question before the library of whether to release this or not. And that was in reference to Imperial Merchant Services Incorporated versus Hunt. And then he goes on to quote, indeed, quote, the words of the statute will not be literally construed if this would cause an absurd result, unquote, which is part of a sentence that continues on that's not contained. It's just a snippet of what inside of a sentence in a paragraph. And I think that's absurd to state that the releasing of the donors would provide an absurd result. I think that's ridiculous. I don't understand why, and why not? You know, I think, the DCA Russi, in his own words states, for reasons similar to those discussed above regarding the Sunshine Ordinance, those cases don't regard the Sunshine Ordinance. As a whole, the court would likely find it unreasonable. So I'm not quite following the line of thinking. I'm trying to get to a core of what he's thinking to see whether he's truly giving advice as to this must be released, or the ordinance says it's restricted.
So we don't actually have the written document requesting the creation of this legal memo. But what we do have in the introduction is a summary of what catalyzed this memo. And if we take the language in that introduction as representative of the original question, the second paragraph of the introduction, you have asked whether the agreement requirement compels the library to obtain an agreement from Friends to comply with the entire Sunshine Ordinance, or alternatively whether Friends must agree to comply with only the gift disclosure requirements of Section 6729(6). Maybe it's a little bit of a leap to say that if you ask an attorney, do I have to comply with this, the attorney will give you the best case to not comply with that. I know that's how attorneys work when I hire them. I don't know whether it's fair to say that's how the city attorney works in relation to its agencies. But to me, it seems like basically, with what we can read, the prompt was, do we have to do this? And what was provided is an argument as to why you wouldn't have to do it, which to me does seem like it meets the purposes of not turning over information or 6721I.
I guess for me, if when it comes down to, like I said, you got to have, I feel like I would need to see something that's kind of an egregious, maybe there's a smoking gun kind of thing that you find out through some other sources. Or if, for example, you had a memo that was kind of objectively way off base, that could maybe be, very sufficient evidence of you were, intentionally trying to flout the Sunshine Ordinance. The issue with this particular memo and the question that it is analyzing and why they're going through absurd results and reasonableness is that it's interpreting a provision of the Sunshine Ordinance that is not clear It is not clearly worded about what's supposed to be. And people will sometimes have certainty that something is absolutely 100% clear, that you need to, this ordinance says X. And maybe it's because maybe you get 10 lawyers in a room, you're going to get 15 different opinions on whether it does say X or not. But, or if it says Y plus 2. Anyway, I mean, the problem I have with finding this memo that says you don't have to turn over the records is that, I think it's a close read. It's a close call on that particular ordinance section. I don't think I agree with the memo, but I don't think it jumps out as the city attorney's office in this situation was engaged for the purpose of denying the records that were requested. I mean, I can understand the argument and the implication and kind of trying to connect the dots and seeing that. I don't see those dots connected in this situation. And, it's possible that dots can be connected in other situations. I just don't see it here.
Through the chair. Yeah, my feeling is that if we're looking at strictly in legal terms at these memos from city attorneys to departments, we're never going to be able to say for certainty that memo was written for the precise reason of not releasing records. Because legally, as you said, Member Kate, unless the memo comes out and says, hey, you asked me to block these records, here's my reasoning, yeah. There's no way to know, there's no way to prove with certainty. So for me, if I look at it non-legally, to me, these records are public and they should be released. So
But that's not the topic of the complaint, is whether the record should be released. The topic of the complaint is whether this memo from the attorney violates 67, 21?
67, yeah.
21I.
In so acting as, what is the language in 21I?
Acting as legal counsel.
But
for the purposes of denying.
The purposes of denying. That's the question. Is this document an example of a document for the purposes of denying? And I can see how it's construed as such. It doesn't really, make an equal case for denying and not denying. It's a legal argument that a lawyer on our task force says would not be his argument if he were to write it. I don't know whether it's our place to be stepping into the mind of the lawyer, whether they made a fair argument or not. But when I read this, it feels like a case to deny, and so that's where I'm coming from.
Yeah, I'll just say that it sounds to me like you'd have to climb into the head of the person requesting the memo and climb into the head of the person writing the memo. And that's a mental intent issue. That's what makes prosecuting crime so difficult a lot of the time. So there's an intent to do it. Not only that, but I think that when you're writing the memo, if the party ends up using it as justification to not release the records, maybe that wasn't the intent of the drafter. I think that Member Kate's right, the heavy lifting is you're getting at an intent or for the purposes of denying. And that's a very kind of high bar to get over or to prove, really, to show.
Just for the record, Member Tesfaye arrived at 5:30. And go ahead.
Sorry for being late. Here I think you would be looking for something like an email that said, I'm looking for legal advice for this purpose, which, if you are not familiar with the law, you might actually write an email that says that. If you are familiar with the law, you would not write an email like that. I think if you are really familiar with the law, you wouldn't ask for something like that. You know that through your training that all city employees undergo, we're supposed to be disclosing records. So I do think that is the kind of documentation that you would have in order to substantiate a complaint under 67.21I. Getting the intent not from climbing into the brain of someone, but finding an email where that kind of legal advice is requested. And a memo in response to that would say, the issue here or the question that has been asked is, how can I not comply with the Sunshine Ordinance? How can I not release these records? And that's what you would need to have in order to substantiate, this kind of claim or some other evidence of that kind.
Mr. Hartz, and then I'll get to you. Mr. Hartz? Have you requested the antecedent document that created this memo? I.e., have you requested the request for...
Yes, but none was produced. They said attorney-client privilege.
Yeah, I guess they would have. Yeah, okay.
So I just want to get back to 6721I because I think it's a guide, okay? And it's a guide specifically for this area of law around the disclosure of public records. Everything else that's on the table with regards to if a third party had gone into and filed a lawsuit for the release of public records in a legal court of law, that's where the charter becomes activated. But in this particular venue, for this particular purpose, and the requirement of the city attorney, as it's named, the San Francisco city attorney's office, the whole department, the whole agency, shall not act as the legal counsel for any city employee or any person having custody of public records for the purposes of denying access to the public. Then you have to determine if they did that, whether they actually wrote something to actually deny access. I hear what Member Tesfaye is saying with regards to you got to find a smoking gun somewhere. But I think in a lot of ways the request is the smoking gun. They're asking, do I have to reveal this or not? And when you look at the response and the response, you can climb into the head just by reading Mr. Rusi's very extensive and concise response, and the way that he crafted it. I think it's to me it's very clear. This is a way to find ambiguity, and if you always are finding ambiguity and you then leave it up to the client to make a decision, is very questionable to me. I think the city attorney, it should be somewhat black and white. It shouldn't try to find ambiguity. And if there is ambiguity, I would really expect the city attorney to come to us and say, I've got a problem, and maybe, consult with us as they're supposed to with regards to sunshine and sunshine training and what have you. I think there could be a little more friendlier relationship in that way because some of us are members of the public and some of us are members of the bar. I mean, this diversity is very important because the Sunshine Ordinance leans towards everything to be public, leans towards the people, and the representation of the city attorney is also, as it says, to protect and secure the rights of the people of San Francisco. So I really want to look at it from that perspective to what their mission is and their purpose is. And I think this, if we look at Section 6721I as kind of a guide, the first sentence, if you make that like step one, is that they should not act as legal counsel. And step two is if somebody does request whether a record or information is public, they should make that opinion public. It's not an attorney-client privilege thing. That doesn't even apply here. So for the city attorney to invoke it in a non-legal procedure, then I think that 6721 actually applies. And the argument that the respondent is putting forward is moot. And that's where I think that's where we should stand. We should look at it for what the words on the paper are. I don't think 6721I is ambiguous at all. I think it's very clear and it's very succinct.
It seems to me that what you're describing as the principle or the reason behind 6721 is clear, that the idea was not that the city attorney as an office should be engaging in preventing records from being released that otherwise would be released. The question is whether or not this is a smoking gun. And to me, it seems like we have a gun that smells like gunpowder, but we can't actually see if it's smoking because the document that would identify what the original request is shielded from attorney-client privilege. So all we have available to determine this is what's in this memo. And to me, this memo is as close to a smoking gun as we're going to get without legal malfeasance on the part of the city attorney.
I have to question as to why you think that the communication from the respondent here, the library, or the client, why you think that communication between is important at all. The ordinance is not requiring that. It doesn't say shall not act as legal counsel for any city employee or any person who has made a request about whether a document or record should be denied access public. It says should not act as legal counsel for any city employee or any person having custody of any public record for the purposes of denying access to the public. It doesn't discuss any action.
I mean, I still feel that the context of the request would help inform the nature of the memo. But without the context of it, I feel that the introduction alone, on the face of it, without other evidence, indicates that it is a document explaining how the legal arguments to not turn it over. So to me, it feels like a violation of 6721. I do feel that having the document that catalyzed this would be helpful to confirm that, but I understand where you're coming from. Go ahead.
Oh, I keep not liking where I'm going here, but as I'm reading the charter and as I'm reading the ordinance, I don't think there's an ordinance remedy or there's an ordinance violation for the city attorney's provision of advice, even if the city department said, give me a reason, give me a justification. I don't like saying that. I think that the remedies for those kinds of what we might perceive in this room as abuses of that kind of power or decision-making by the city department and then the acquiescence in the city attorney's office to fulfill that role, I don't think we like that. But I do think that the charter is pretty clear that one of the things the city attorney's office does is provide on request advice or written opinion to any officer. It doesn't necessarily say provide advice to, that is in the best interest of the public as decided by, Group X or Department X. It could be someone calling up the city attorney's office and saying, I want a justification for this. It doesn't have to be in the public records context. It could be anything. And it's easy to sort of envision less nefarious requests. In this context, it's possible. I don't like it, and I don't know maybe how this would shake out, but I think that it's possible that a city official could ask for legal advice on how to withhold a document, for example, if they thought it was going to harm the public safety. And they could say, I don't want to produce this document. What are the legal bases for allowing me to make that decision? I think the charter every time is going to trump the ordinance on whether the city attorney's response to that request violates the ordinance. And ultimately, that's kind of the way I come down on it. If we don't like the city attorney's office being able to be used in that way, then we need to. Then I think ultimately the fix is in a charter amendment, and it will not be in an ordinance application of 6721I.
So I don't know if the charter trumps the Sunshine Ordinance, but if so, it would have to be proven legally in some type of a case. My feeling here is that we've discussed this. I think if there's a motion and it comes to a vote, it's going to depend on how each individual here feels this memo is. It's a totally subjective call. right now. Was this memo written to not produce records, or is it an objective memo? And we can discuss it for the next couple of hours, but to me, that's what I feel the issue is. So, if there's a motion, that's what it's going to come down to.
I think you make a good point. Is there any last thoughts before we hear rebuttals from our two? Go ahead.
Yeah, through the chair to Member Kate, I'm not necessarily in agreement with. I understand what you're saying, and I think from a legal point of view, with regards to attorney-client privilege, that is correct. But I think the ordinance is every ordinance. If the charter trumps every ordinance, everything that's underneath it, then it can be claimed. Then any elected or any department head or any city employee could claim that. Okay. Then what's the purpose of having these codes? Okay. They're there. They're law. Okay. And where there isn't any quote unquote ambiguity, then you're supposed to follow it. Okay. I think it's important that where there are high-level officials that are supposed to be upholding the law for the people, and where there is law that states, state law, federal law, that states all government records are to be public, unless you can prove or show a citation that they shouldn't be, okay? That's a different story. Now, when you look at, again, I go back to the charter, and I'm reading. I don't see it in any other line in the charter for this particular kind of issue, but it says the city attorney shall represent the city and county in legal proceedings with respect to which it has an interest, and that's a question. Does the city and county have an interest in this? Is this legal proceeding? I don't think legal proceeding in a definition is, and lawyers correct me, legal proceeding means this administrative process.
I do.
I don't read the reference to litigation or legal proceedings in paragraph 1 of 6.102 is one of the responsibilities of the city attorney's office. It's the one that's got several paragraphs to it. It's a long one, but probably because it's pretty important. It's kind of confusing maybe, but then there are 9 other responsibilities of the city attorney, and responsibility number 4 is provide advice or written opinions, and that's not connected to pending litigation or legal proceedings. It's day to day. Like, will we violate some kind of ordinance to please turn on the air conditioning? That might be a legal opinion. That would be a legal opinion that under the charter, paragraph 4, they're doing unrelated to legal proceedings, but it's a responsibility under the charter.
I just have a quick question, again through the chair to Member Kate. Do you read this paragraph in sequence at sequitur?
No, these are all
they all
stand separate responsibilities.
Okay. So even though, like in number 5, it talks about legal proceedings.
Yep.
Okay. You don't, because number 1 starts out stating that the city attorney shall represent in legal proceedings, that number 4 does not apply to. It applies to everything?
It applies to any time any city officer, department head, or board, commissioner, or other unit asks for advice. So for example, your example on paragraph 5.
I'm asking as a layperson.
No, I understand. I understand. Yeah. So the fact that the charter here reapplies or reuses the designation legal proceedings in paragraph 5, to me that's showing you that it's a separate responsibility than the one enumerated in paragraph 1, because they're saying it again. Whereas, so for example, another way to look at it is paragraph 7 and 8, where these things have they possibly could have a bearing to legal proceedings, but, making available to the public a codification of the ordinances. That's not going to be related to a legal proceeding. I mean, again, it could be. Same for, number 8, annual edition of the charter you got to publish. That's not going to be in connection with the legal proceeding. So, I mean, I view these 10 responsibilities, they're all kind of 10 different,
So
requirements.
6721I should be struck out?
Well, that's where
that doesn't make sense to me. The law has been in place for over a decade.
So I've got a question for our city attorney here. Essentially, what I'm hearing from my colleagues is that the charter is in conflict with 6721I potentially. I'm trying to find out whether our charter as the Sunshine Task Force, whether our master is the charter itself or ends with the State Public Records Act and the Sunshine Ordinance. Because it seems to me that whether or not 6721 I or 6721 is aligned with the charter isn't really our purview to assess whether the charter is in line with city ordinances. Do you have any thoughts on that?
I'm not sure that I agree with you on that, but
sure. So you kind of said a lot of different things there, and the way I'm interpreting your question or comment is like the extent that the city charter, if there's a conflict with an ordinance, which one prevails, and in that instance, I would say that the city charter does.
I can understand how the city charter would in a court. I'm asking whether, as the Sunshine Ordinance, all of us have studied the Sunshine Ordinance. As far as I was concerned until about a moment ago, our Bible is the Sunshine Ordinance, the California Public Records Act, the Brown Act. And anything in the charter that's beyond that felt like it was beyond that to me. So I'm asking whether, if the Sunshine Ordinance is in violation of the charter, if that's within our purview to identify or not.
Well, I guess I take issue with your premise that you don't really have to regard a court's interpretation of what the charter might be saying or how that might interact with ordinances, in the sense that you're saying our Bible is not what the court says, it's what these ordinances say. So to the extent that a court has spoken on an issue, or if someone is reading court decisions and trying to predict how court might interpret an issue, I think that should be the way to frame your issue, because at the end of the day, if this is ever challenged in court, that's what these lawyers are trying to advise their clients, if there's not a clear case on it. So to the extent that there isn't an issue, isn't a court hearing, I understand the documents you're looking at, the ordinances, the charters and whatnot, but I do think it's helpful to look at the court decisions as guidance.
Right. I mean, I'm saying that, it feels to me what I'm hearing from Member Cade is that the charter or state law basically invalidates 6721. Is that a...
Maybe.
It depends.
I think finding a violation of 6721I by the city attorney's office, which I guess is the only office that it's really applicable to, I think it would be very hard. Were someone to take an action, across the street, a couple blocks to SF Superior, and say that the city attorney needs to be enjoined from, engaging in the type of behavior that 6721I on its terms seems to prohibit, I think that would probably lose based on the charter and based on the discussions, I guess, that I've had and the interpretation that the city attorney, the office exists to advise city departments.
Right. And I guess where I'm coming from is the question is that sounds like what a judge might determine.
Right.
And I'm asking, is it irresponsible for this body to look at the universe of the Sunshine Ordinance and not try to interpret how the city charter in conflict with the Sunshine Ordinance might be adjudicated in a court? In other words, I'm comfortable finding a violation, although your concerns about 6721 not being legally soluble is where I'm
Right.
have concerns.
And I mean, I think we can't ignore other areas of law that, and this is where this job gets tricky, because I'm not an expert in how charter interacts with ordinance. But I mean, I do believe, and St. Croix makes it clear that when there's a conflict, the charter controls. But it's not as straightforward as, you know, it's hairier than that. I think we have to try to keep those things in mind. You know, sometimes they're just like we have to look at other provisions of, you know, the government code whenever there's an express exemption that maybe an agency has claimed that kind of ties to the PRA that then ties to the ordinance. Sometimes our wheelhouse expands based on, you know, basically the issues in front of us.
But the only way that we would ever figure out which of these two things that are in conflict is if we found a violation and then it somehow found its way to court for a court to make that determination.
Right.
Everything else,
like the St. Croix case where there was a fight over the communications at issue, the writings between maybe the memos, and that went. I don't know if I think that was before the task force, maybe it wasn't, but we might have outside of St. Croix determined, well, the ordinance is clear that, and here's how we read it. And we may have made a determination out of the facts of that case that there was a violation and that those opinions should be disclosed, because the ordinance is really clear that on its terms that legal opinions by the city attorney's office on public records issues should be disclosed. And that's very clear. And we probably would have made those determinations as a task force up until a court says, and then maybe, you know, it depends on what we view our role here as, and we can make those determinations. We could still say, forget about St. Croix. That's something that I think we each have to decide on our own. You know, whether we should be saying how the ordinance ought to be applied, how the ordinance will be applied. It's kind of just depends on each individual members.
I would posit this. I think we need to, there are some very clear points of function in the ordinance. And the first point is whether this is a legal proceeding. Okay? I'm not sure it is, because it has no force of law, except for what we determine is being a violation of the ordinance. And frankly, for this particular section, I don't believe is in the CPRA. I'm not sure. I haven't researched it that far. I think this particular complaint is unique to our Sunshine Ordinance, and there are various other unique areas that are not contained in both the CPRA and the Brown Act. So looking at that, we kind of have to contemplate our navel as a city and county as to whether this applies to us, within it. I mean, the court was clear that under attorney-client privilege, the charter would supersede the ordinance in this section. The question I have is whether it was appropriate for the city attorney to invoke an attorney-client privilege, because the ordinance is suggesting that it shouldn't. The ordinance is saying that it should not act as legal counsel. And if you're acting as legal counsel, then attorney-client privilege then applies. But it says that it shouldn't act as legal counsel in legal proceedings. And I think to me, is the crux of the question. And I would move to continue this case and formulate some way to find out.
Is that it? We haven't heard rebuttals yet.
I hear you, but I said I would move, but I'm not making a motion yet.
Right. All right, so someone's mentioned a possible continuance. With that said, are we comfortable moving to rebuttals? In case we are continuing this, then we might as well.
I just keep going with the process when we get to that.
Yeah, I hear you. I'm just saying, Are we comfortable with rebuttals at this point? Great. Complainant goes first, right?
No, respondent.
Respondent?
I think it's the last word.
Excuse me. Thank you, task force members. John, for the record, John Cote, Communications Director for the City Attorney's Office. I appreciate the in-depth and wide-ranging discussion that you've had about the intersection between the charter and ordinances, but with all due respect, this issue doesn't even need to get that far. And I would point you to the plain language of 6721I, and it's the specific phrase that I believe Task Force Member Cade emphasized earlier, which is for the purposes of denying access to the public. So I would suggest that you have no evidence before you that our office acted in a way that was for the purpose of denying access to the public. I believe it was Vice Chair Wolf's point about wanting to see the underlying request for this memo. That's an issue that's just come up now, but I would point out that you have absolutely no evidence before you that there was a written request and that there was for that, or that Mr. Hartz had requested it and that our office had exercised attorney-client privilege. That's just simply not in the record. I can't shed light on it at this moment, but I would point out that you simply don't have those facts before you. All you have is the representation of Mr. Hart. Beyond that, I would note that the role of our office, as is the role of any good attorney, is not to provide the guidance that your client wants. It's to provide guidance on what the law says and what the law is. So we're not guided by a specific ideology. We're guided by what the law says. And so in the work that our deputies produce every day, and I should note to Chair Wolf, or that's not currently acting Chair Wolf, you referred to me earlier as DCA Cote, and I'm not a deputy city attorney, so I just wanted to make sure the record was clear on that. I'm the communications director.
Okay, thank you.
So with that being said, I would reiterate that there simply is no evidence for a violation of 6721I here. You don't have any evidence that our office acted for the purpose of denying access to the public. And that's the warning chime. So in addition, if you do get to the question of whether or not the charter is in conflict with the Sunshine Ordinance, then I would suggest that you can't ignore the law. And the law is clear. We have a case on point, which is the St. Croix case, which, as I noted earlier, is the determination of the Court of Appeals. It's a published decision, and it says that when there was a conflict between the charter and an ordinance, the charter controls.
Thank you. Mr. Arts?
Remember that old expression, you can't see the forest for the trees? One of the things that when you go to court, you're often asked is, did you exhaust all local remedies? Well, obviously, I have exhausted local remedies to a large degree. And I will tell you right now that if you look at these individual cases, 2/3 of them are about the Friends. What does the Board of Supervisors know about the deal between the library and the Friends? What does the controller know about the deal between the library and the Friends? What does the mayor's office know about the deal between the library and Friends? What does the city attorney's office know about the deal between the library and the Friends? Originally, when this deal between them was taken to the Board of Supervisors, former Supervisor Leland Yee said, no way. The library is not getting anywhere near enough. I won't approve this. And they threw it out. And they went ahead and entered into it anyway. I'll be honest with you, I don't even think they have any legal basis. I don't know any city department head that really thinks I can just go get a group of private individuals, authorize them to raise money in the name of my department, and be unaccountable for it. They don't have to account to us. We don't ask them, nothing. The bottom line is, We have more than a decade of the library trying to hide the financial relationship between the library and the Friends. And it is clearly established in the public record. The task force has found on 11 occasions that they violated the ordinance, 6 of those having to do with public record disclosures. The city attorney's office was petitioned twice during the one I mentioned earlier of 2 years in length, and denied both of the petitions, and subsequently the deputy city attorney was found in violation by the task force for acting as counsel for someone wanting to withhold the records because she denied the petitions. So basically what we have is a long history of the public library authorizing a group of unnamed, unknown individuals appointed by God knows who to raise money in the name of a city department and account to no one for where that money goes. And when I say you can't see the forest for the trees, they look at these little things, they say, oh, Mr. Hartz, he's just trying to harass people, harass the library and whatever. No, Mr. Hartz is trying to establish a case where everybody involved knows that what's going on is wrong, probably, in my opinion, knows that it's unlawful, and at a minimum, questionable in a moral sense. I don't think any city agency has the right to have private individuals raise millions of dollars and spend those dollars and remain unaccountable.
Thank you. Anyone comfortable making a motion at this point?
I just have a couple of comments first. For me, there are 2 issues in the complaint. One is, did the city attorney act as legal counsel? And 2 is, did they provide advice for the purpose of denying public records? That's what this particular complaint is about. The charter doesn't speak to whether the release of donors for that's described under 6729.6 should or shouldn't be released to the public. This is uniquely specific to the Sunshine Ordinance. It doesn't say they can't collect. Basically, in the charter or maybe the administrative code, it may say, or even the section for the library may say they can receive third-party donations. Okay, they've got the ability to do that in compliance with the charter or some other subordinate code or ordinance. DCA Rusi's advice doesn't speak to that, which is the crux of the question that former librarian Luis Herrera was asking about, in addition to whether the Friends of the San Francisco Public Library are required to comply with the entire Sunshine Ordinance or not under 6721I. So I'm not so much concerned about whether they have to comply with the entire ordinance or not. I think that's a question for another day. I think what's important is to whether, first of all, whether there is an attorney-client privilege, okay, for the purposes of what purpose? Well, it would be for the purpose of whether it's for legal proceeding, okay? Because I believe that even though the request came before the complaint to us, it doesn't matter because everybody knows that if you receive a Sunshine request and you don't comply with it, you're going to come here. More or less, it's going to end up here. And I think with the relationship between the petitioner here and the library, it's pretty clear that, that would happen. So they're asking advice in preparation for a possible complaint. Because in Mr. Herrera's mind, I think it was, we don't, the Friends don't want to release this information. And, I don't think that that's appropriate either. So I'm going to ask I can ask the city attorney for that advice because the Friends cannot. They're not a city agency. They can't use the city attorney. So they need somebody else to do that for them. And because of this relationship, Mr. Herrera would be concerned about, because of what you read in DCA Rossi's advice letter, it's all about whether the city would lose money or not. Now, where did that come up in former librarian Luis Herrera's request? I think that goes back to, let's see the original request. But I think it's clear to me, reading DCA Rossi's response, that either he's going beyond the question that was asked him, or he was asked that question directly. Okay? Either way, to me, it feels like there is even just suggesting that there's an ambiguity with all what is it, 5 or 6 pages of context. It just seems a little excessive to make a point. And I think that's that to me that's notable, and I think to me that I do have to go back to whether we are a legal proceeding or not, and whether they're providing that advice in preparation for this proceeding, and whether that they are then allowed to do that or not. So that's kind of where I'm going on that, and so I'm still a little unclear, because once we make this decision and other people find out about the decision, I'm concerned that will become a regular precedent and used, much like we hear about the rule of reason. The use of the rule of reason is whether because of something is so voluminous or so excessive of a request that a respondent can deny compliance with the ordinance for that request based on the rule of reason, and then they don't get the information.
So I prefer to look at this in a much simpler term of just looking at the purpose of denying, of not turning over public documents. The outcome was based on this memo that the documents weren't provided. The introduction to the memo says, are we required to do this, or something very similar to that? I don't have it in front of me at this moment. To me, each of these things is as close to a smoking gun as we're going to get for 6721. I understand that 6721 may not be upheld in court based on what I've heard today, but the only way we're going to actually get a test of whether or not 6721 is legally defendable is by us identifying that this is what a violation of 6721 looks like, allowing both the city and Mr. Hartz to move forward however that looks. And if it finds its way to court, and then it finds its way into appeals court, we may have case law around this. But until we do, it's like us parsing this and the Croy decision and all of this stuff that to me feels like it's at the appellate court level and not the Sunshine Task Force level. So for these reasons, I'm going to go ahead and make a motion for a violation of 6721I.
I'll second.
Thank you. Is there any public comment? Absolutely, sir.
My name's Robert M. Smith. I'm here on another matter. But listening to this...
Can you come closer to me?
Listening to this, sorry. It seems to me that you are collectively talking again and again about an ethics issue, and an ethics issue applied to attorneys. And lawyers are held to a different standard. And I suggest there are 2 possible action steps that you may or may not at some point wish to consider. You're clearly not comfortable collectively with the city attorneys giving advice that public records are owed to the public and not giving advice to city agencies and departments on how to withhold such records in defiance of that. Bearing in mind that truly public attorneys, as your colleague here will tell you, are held to a higher standard. This is an ethics question.
What did the city attorney do, and how should it have done that, and what standard is it held to with regard to counseling city departments as to you? The Bar Association of San Francisco and the State Bar of California both have ethics mechanisms. Any lawyer can call and say, what's the ethical answer here? I'm suggesting to you that the application of an ethical standard to the city attorney's office may not be a bad idea, given what you have consistently spoken about tonight. The second thing is, you can get your own attorney very likely free. Don't be in the uncomfortable position of saying there's a wall in the city's attorney's office in which our lawyer is in some magical way held off from everybody else's. You can get a pro bono lawyer, a really fine one, from a large city law firm. I used to be on the board of the San Francisco Neighborhood Legal Assistance Foundation. You can get one free whose entire commitment will be to you and the freedom of information and carrying out the Public Records Act and not worrying about another city agency, a current political incumbent in the city attorney's office, or walling off that office. You can have your own lawyer. I'm suggesting a first-rate one without pay. But at the end of the day, it's an ethical problem you're discussing. And all the dancing around about what were they asked for and how did they respond, were they biased? You know, that's something you shouldn't have to ask about a lawyer. Thank you.
Thank you. Any other public comment? Thank you. All right, go ahead and call the roll. What's that? I made the motion. Kanata seconded it.
Chair Wolf?
No, he goes last.
Well,
Okay.
wait.
He made the motion.
He made the motion. Oh, he made the motion. Yeah. Okay.
Aye.
Member Kanata?
Aye.
Member Kanata, aye. Member Yankee?
No.
Member Yankee, no. Member Martin?
No.
Member Martin, no. Member Tesfaye?
No.
Member Tesfaye, no. Member LaHood?
No.
Member LaHood, no. Member Kate?
No.
Member Kate, no. Member Hensy?
No.
Member Hensy, no. Member Highland, absent. Member Wolf?
Aye.
Member Wolf, aye.
Is there another motion?
So what's the result?
The motion failed.
The motion failed,
Motion
yes.
failed. Okay, so I would like one of our committees to review and research whether we are a legal proceeding or not. I think that is the hinge to all of this. Because if we're not a legal proceeding, then the Sunshine Ordinance prevails. And so I would move that we, I don't know which committee we should put this under.
So can we talk about that briefly before
Sure,
you?
yeah.
So I'm not sure I agree with that because, like, particularly with Mr. Hart's, but it would apply to anyone. You have a question of whether something's a public document and whether or not we are a legal entity. Eventually, it could end up in court, at which point it would be a legal entity. So at the point that someone asks for a document and they ask for legal advice from the city attorney, it hasn't become a Sunshine Task Force issue yet either. And it will eventually conceivably become a court issue of, like, someone could sue. So I don't think that whether or not we are a legal entity is in any way the determining factor.
If I can, I just want to rebut that because the way the ordinance is written, it doesn't state any of that with regards to this proceeding. It just says, in general, before a complaint comes to us, that at any time the city attorney shall not act as legal counsel for denying access to the public.
Yeah, I agree. I'm just saying that whether or not we're a legal entity doesn't actually feel like the deciding factor.
Well, but it is because the crux of the matter is the attorney-client privilege. The complaint here is about whether the city attorney acted as legal counsel appropriately under 6721I. And 6721I says it shall not act as legal counsel for any city employee. And then the point is that then when do they become legal counsel? They become legal counsel when there's a legal proceeding. And so the question is are we a legal proceeding or not? If we're not a legal proceeding, then then Section 6721I applies.
But if there's a financial agreement between the city and a vendor, and there's a contract,
yeah,
that's not a legal proceeding. But the city attorney is still going to review that contract, right?
No, but he was asking, former librarian Herrera was asking for advice specific to the Sunshine Ordinance. It wasn't just about a contract. It was about the Sunshine Ordinance itself. That's why I'm saying it. That's the application here. It's not some external issue. The ordinance speaks specifically in 6729 around what the responsibility is of of third parties that are providing funding, sources of outside funding. It's very specific as to what they're supposed to do. And the first question is that Mr. Hartz brings forward is, did they act as legal counsel? Okay, and the second purpose is for denying access to public records. Yeah.
I have a question on that. So how is the situation different from what interim acting chair Wolf just brought up? Because in his situation, the review of the contract is to make sure that it is legally compliant with our contracting rules and laws. And in this case, they're asking, what constitutes legal compliance with the Sunshine Ordinance? So I'm trying to figure out how is it actually different from what Acting Chair Wolf brought up.
Because if you're talking about a specific contract that has no application to the Sunshine Ordinance, and they're concerned about some legal action, court action, then it's appropriate for attorney-client privilege.
Is that what he was saying? Because I thought he was talking about legal compliance. Like every contract that a city agency, a state agency is entering into is reviewed by legal division and for compliance with the contracting laws. So here I see this as a legal compliance matter, as it is a legal compliance matter that...
Well, that's the point of this. Does 6729-6 apply to all of these sources of outside funding? It's not even talking about a contract. It's just talking about money that's donated to the city.
Except that we're talking about a very broad issue that happens all the time, that in this case, Mr. Hartz's complaint revolves around the Friends, which is where 629-6 comes in. But there is a historical issue here, which is what the complaint is about, which is the city attorney providing memos that lead to documents not being turned over. Now, whether the purpose of that memo is to deny documents is the heart of 6721, but all the issues of outside agencies and that stuff, like that's related, and that's central to Ray Hartz's related case to this one. But in this case, I don't think anything beyond whether or not the city attorney can provide a memo that results in documents not being turned over, whether it relates to the Friends of the Library, in this case, it's this weird thing, or the Department of Building Inspection asking the city attorney whether they have to turn anything over, and then them saying, no, our legal advice says we don't have to turn this over. That is, to me, the universe of this complaint. The fact that it happens to relate to Friends, I don't think actually pertains It doesn't pertain to the language of the complaint itself, which is just about the city attorney providing advice to deny public records.
I don't necessarily agree with that. I don't think we need to look at the how it contextually applies to other things. We're looking at how it applies to this particular case. And the question is first, is the activation of attorney-client privilege create legal counsel? That's the very first thing. And the second thing is whether the advice that was provided, does that constitute a denial, advice on how to deny, the records, the public records.
I agree completely. I think that's the universe.
Okay.
And it's been voted on. I really.
Well, but the thing is this is going to come back. This is going to be, I think this is one of those, again, we have to contemplate our own navel with this particular issue. I mean, there are other issues that have been also unfounded based upon not getting clarity about like a relationship and about how this works. And so, I hear and I understand what the respondents' arguments are. I'm not necessarily in agreement with the original advice that it was not providing information on how to deny. I think it did by stating that a court might find it ambiguous in some way. I think that is direct instruction on how to or why not to provide it, and take a chance, take a risk, in doing it, because there's all this possible or potential evidence that might show that it might be valid or not. Okay, there's no clear answer here. Even it's all interpretation in that advice. So the question is whether that advice is providing enough guidance for denying. And I think, to me, it's clear. There's so much of it in there, and how and the context of it, it makes it clear. He repeats over and over again that if anybody wrote a check or provided $101 in cash, that could upset the entire city in receiving any kind of outside funds, because you got to release the donor's name. Well, that happens every year in an election. I don't understand why this is such a high hill to climb. It's in that way. And then the second issue, I think, needs to be cleared up as to whether what constitutes whether the city attorney can, where is the threshold of legal counsel and not being allowed, being restricted from legal counsel under 6721 as applied to the charter. I think that interpretation needs to be made. And I think the question I asked before as to whether this procedure, this process that we do here, is a legal proceeding or not.
So it seems like we can either continue this and refer it to a committee, or we can table it. What were you saying?
I was just going to echo what you said earlier. I think legal counsel, it doesn't matter whether this is a legal proceeding or not if they're offering legal counsel and this being a legal proceeding are two separate issues, unless I'm misunderstanding.
Yeah, they're saying that if it is a legal proceeding, then the charter supersedes the ordinance in providing actual legal counsel, which gives them the opportunity to use attorney-client privilege for advice in this way. If this is not a legal proceeding, and it's an administrative process, as we've kind of been reduced to by a lot of elected officials and high-level city folks, way back when, then that doesn't apply. The charter doesn't apply because it's not a legal proceeding. So, and the ordinance is, I think the framers knew that. They were lawyers. and I think they interpreted the charter correctly.
So, a question for the lawyers on our group. We lost one, but how often do you give advice based on the law that doesn't fall under attorney-client privilege or doesn't qualify as legal advice? Like, if there's a special carve-out why it's not attorney-client privilege, I get that, but it seems to me that anytime a lawyer opens their mouth about the law, it's legal advice.
Yeah, if it's to a client, it definitely is.
Same thing and I work for a state agency.
So that's where I'm at, is that essentially any document that is written by the city attorney is legal advice. Now, whether it's exempted from attorney-client privilege because of 6721 or the St. Croix, or how those two things interact, is a whole thing to unravel. But I just don't understand how an attorney can give advice that's not legal advice.
Again, if you read 6721I, it's clear. I think it runs in it's a process. It's guidance. First, that they shouldn't represent or be legal counsel for the purposes of denying, okay, and that any opinions that they make must be public. And that means it's not attorney-client privilege.
I think it is attorney-client privilege. It's just that due to the statute, that attorney-client privilege has been waived.
No, it says you can only invoke attorney-client privilege if you are providing legal counsel. If you're not providing legal counsel, there's no attorney-client privilege.
Or is it a waived attorney-client privilege?
I don't. From what you just said, I don't know how we're in disagreement. If you're providing legal counsel, it's attorney-client privilege.
Right, and so what I'm saying is that if the charter says that they are to provide legal counsel for the purposes of a legal proceeding, and we are not deemed a legal proceeding but an administrative process.
Administrative processes are considered legal proceedings. That is almost all of my practice. So I do completely disagree that administrative proceedings are not legal proceedings. That's absolutely not true. There is administrative law. There is the APA on how you handle administrative proceedings. That is legal advice.
Well, I don't know if we're an administrative procedure or proceeding or not. I don't know what we are, because we've been challenged and reduced in so many different ways. People claim us to be a lot of different things. Some people say, well, because your whatever determinations are, they're determinations. They're not orders. It's an order of determination. There's no action out of it, but that it can be used in a court of law and has weight in a court of law that makes it legal. But then there's other opinions that we're just actually our opinions mean nothing.
Right. I think
because only a court of law would make a.
So I don't think the discussion point here has to do with what we are, but what service this attorney is providing, and they are providing legal advice on how to be in compliance with the ordinance, not anything else. And so, in that sense, it is legal advice. That is this is a very standard compliance memorandum that an attorney would provide to their client in order to prevent a lawsuit, in order to prevent not being in compliance. And for many, many attorneys, possibly most attorneys, this is all that they do.
That particular kind of opinion that was written?
Yes.
So
people want to avoid having to go into litigation. It's very expensive.
Right, but that's the point of 6721I.
So I feel like we're going
for that not to happen.
I feel like we're going in circles at this point, and I would either like to continue this either to an ad hoc committee, or I guess EOTC would be the closest committee because it's not compliance. So I'd like to either table this or continue it. Is there a motion to continue it, or are people more interested in tabling it?
I would move that that this discussion and to come and try to come to some conclusion, so that we can, when more of these cases come up, that we have some guidance as to.
I mean, we've been at this for an hour and a half.
No, I
don't
know
think we're
that.
going to get to conclusion tonight.
I'm saying that I would like for a committee to move to have it that be put to a committee for
So a continuance heard by a committee.
Yeah.
Are we continuing, excuse me, I'm sorry, the complaint? Or are we continuing, so the complaint?
I'm going to refer
Like the issue, the discussion.
I'm going to refer this issue to EOTC.
I think that we should leave the complaint open attached to the issue, because if we, and the result of EOTC, determine that this advice situation is what it is, then we should still be able to find the violation. Like what happened was we failed to get the votes for a violation. I think that it should remain open as a motion to continue to EOTC to then come back to us, because if EOTC does determine that this is an issue, then we have the situation where Ray Hart has to refile the complaint. We have to decide.
Okay, so I'll rephrase. So I move to continue this item and refer the question of whether the task force proceedings are an actual legal proceeding, and whether the city attorney is requirement of the city attorney or allowance of the city attorney under the charter supersedes 6721I.
Great. And I would like to ask, because this is kind of a unique case, for the clerk to notify all of the task members when it comes up before EOTC, with the chair's permission.
Yeah.
Great.
So are we allowed to continue an item that's been voted on?
It hasn't been voted to find no violation. Right now it's just sitting there because if a motion there's no motion that's passed. If I made a motion to find no violation and that passed, then there'd be explicitly no violation. But you could make a motion to find a violation is 6729-7, which doesn't make any sense at all because it's still open right now.
Yeah, this has happened before. We've made, motions, the motion has failed, and somebody else will make another motion to see if they, let's say it was for, multiple different violations, and some people say, well, maybe for the first and second one, but not the third one, and they'll vote it down, and then you create another motion, that kind of thing. That happens, so, yeah.
Can I add something, just a comment on where we're going with this? I don't think the crux of the discussion should be on whether this specifically is a legal proceeding, but if the activity that is occurring between the attorney and the client is legal advice for compliance with the law. I don't think the crux of this discussion is for determination of attorney-client privilege is whether this is a legal proceeding. Or an administrative proceeding. It's whether that was actually legal advice for compliance with the law, because that's what the attorney was doing.
And I would like to add, in addition to what you're saying, that EOTC look at whether 6721 is legally valid, because a lot of this stems from St. Croix and all these things sort of undermining 6721, and I would love to hear from EOTC essentially an argument 6721 is valid or 6721 is kind of limping along.
I would just, to Member Tesfai's point, I'm not necessarily in agreement with that, because 6721I speaks about whether they should be legal counsel or not. In any case, whether it's a legal proceeding or not. When I'm talking about with regards to legal proceeding, actually determines whether at any case that they should be providing legal counsel for the purposes of coming here. And
how about for the purpose of compliance with the law?
No, not with regards to compliance with the law, but by the same token, the law that is central is ours, the one that we oversee.
Just because if you look at the actual memo that is in question here, it has to do with compliance with the law. It's
our law.
I mean, it's not just the law of this body, it's the law of the city. So we can't be, it's not our law, it's the law of the city.
No, I get that, but it's the law that we oversee.
So we have a motion
It
to
applies
continue this to explore
That's in our
it.
jurisdiction.
We have a motion to explore these questions in that committee, and for the sake of time, is there a second on that motion to continue this?
I second it.
Wait, didn't you make it?
I made the motion. Sorry. Yeah. I thought you made the motion.
Is there a second?
I'll second.
Excellent, thank you. Is there any public comment on the motion? What?
He said don't pass it.
Don't pass it. Okay. Thank you for that public comment. Go ahead and call the roll.
Member Wolf?
Wait, I didn't make this motion.
No, the other member will.
You can still call me
Not
chair.
acting
It's fine.
chair, Wolf.
Yeah. Yeah, aye.
Member Hensy?
Aye.
Member Yankee?
No.
Member Martin?
Aye.
Member Tesfaye?
Aye.
Member Kanata?
Pass me for now.
Member LaHood?
Aye.
Member LaHood, aye. Member Kate? No. Member Kate, no. Chair Wolf?
Aye.
Motion passes.
No, member
Member
Kanata.
Kanata.
I'm going to go no,
Kanata.
so the motion passes anyway.
There's 6 votes.
So what's your vote?
No.
Okay.
Okay.
No, there's not.
6-5. 6-3.
6 to 3.
And it's not substantive?
All right. Next item, please.
Item number 10, file number 18081, complaint filed by David Tucker against the Office of Labor Standards Enforcement for allegedly violating Administrative Code Section 6724B2 by failing to respond to a request for litigation documents in a timely and or complete manner.
And do we have both the complainant and respondent here? I see 2 hands. That looks good to me. All right, let's go ahead and get started by hearing from the complainant.
Good evening. My name is Dave Tucker. Peggy O'Donnell and I were here about 6 months ago requesting, with respect to a request to the Office of Labor Standards Enforcement for a copy of a settlement agreement between the OLSE and the Archdiocese of San Francisco. Our request for that document was denied by this group. And we have later learned that there are things that Mr. Mulligan said at that hearing, which we think are misrepresentations and which tainted the proceedings. And so we are here, in effect, to have a rehearing, which is not tainted by what we think are false statements. I'm going to be referring to a June 4th, 2019 memo I sent to Ms. Ledger, which is in your packet, and also I'm going to be referring to the settlement agreement itself. We actually later got the settlement agreement. Mr. Mulligan provided it to us, and we have read it. So in that sense, he finally did what we wanted. What we're here to talk about and complain about is the procedure that happened to us about 6 months ago, which we think is unfair. I'm referring to my September 4 memo. First of all, I want to quote the language that Mr. Mulligan, that is in the order of determination that this group put out. Quote, Mr. Mulligan stated that the requested settlement agreement between the Archdiocese and the OLSE that they are negotiating is being reviewed by the judge in the class action and cannot be provided until the class action suit is settled and released by the judge, unquote. The class action is a piece of litigation that was filed against the Archdiocese because a lot of people thought the OLSE was not doing its job in connection with the termination of millions of dollars of health benefits owed to Archdiocese employees. That is a separate lawsuit going in tandem with the administrative proceedings of the OLSC. That statement by Mr. Mulligan in your records, we believe, is full of falsehoods. The Archdiocese and the OLSC are not, in our opinion, negotiating the settlement agreement between them in 2018. In 2019, the settlement agreement was actually signed in September of 2018. There's a typo in my memo. It was signed in September of 2018, and therefore it was not being negotiated when we asked for the document. So the negotiating exception, which Mr. Mulligan referred to often, does not apply. Also, we believe it is not true that the settlement agreement is, quote, being reviewed by the judge in the class action. I attended a hearing in the class action suit about 5 months ago where the issue of this settlement agreement came up. The judge discussed with the attorney for the class action people the existence of that settlement agreement, and she had absolutely no information about it, had never seen it, and she was suggesting to the attorney for the class members that it be made available to them. So I don't think she's ever seen it until recently. We gave it to her in some papers that we filed with that court. I want to talk also about the issue of what negotiating amounts to. I think Mr. Mulligan, in several occasions during our hearing 6 months ago, was asked by members of this group about the status of the settlement agreement, and I think he implied or said to this group that it was being negotiated. I think if he said that or anything like that, that's not a true statement. When he was asked that question, the settlement agreement had been signed for some months. There's nothing in the settlement agreement, if you read it from beginning to end, that indicates that it was open. Also, there's nothing in the settlement agreement, if you read it, that provides that the settlement agreement is not to be provided to third parties like me or Ms. O'Donnell until after the class action is settled. There's nothing in the settlement agreement about that. Also, when you see the settlement agreement, there are references to it being final in several places. Finally, Mr. Mulligan had said something to the effect that class counsel in the class action had asked him, Mr. Mulligan, not to provide me and Ms. O'Donnell with a copy of the settlement agreement. That class action client or counsel completely denied that. It was very angry about that, and we happen to believe that class counsel on that issue, and we don't believe Mr. Mulligan. So bottom line is, as a procedural matter, we believe the decision that you rendered in favor of the OLSC 6 months ago is tainted by Mr. Mulligan's misstatements, and that the decision has to be overturned.
Thank you. Your time is up.
No, thank you.
Go ahead.
Turn your monitors on.
It was submitted in advance, so it should be with your documents as well. Thank you, task force members. I'm Pat Mulligan, the director of the Office of Labor Standards. As Mr. Tucker indicated, this matter was before you several months ago. I provided a timeline for your review, and I think these are all the relevant public document requests to this complaint. I should note, as I stated before, that this is the first complaint made before the Office of Labor Standards in the 18-year history of the office. This is actually the second time now I've been before you, but since it's the same complaint number, I think that's accurate to state. If I can note that when we were first before you, we stated as a reason for not originally providing the information the California Evidence Code Section 1040 and 1041 and California Government Codes 6254 and 6256 would provide investigative privilege. So that's what we stated. We did get into a conversation around some of the merits of the case. With regard to Mr. Tucker's accusations, in terms of negotiating, yes, we did have a settlement agreement that was indicated previously, but it was contingent on the settlement of the class action case. And consistent with remarks made there, that is when the public documents were made available. So if you go through the timeline, it's a request from October 9th is when our office first cited investigated privilege. The hearing before this body was April 3rd. That is when the Sunshine Ordinance Task Force voted 7-0 that the Office of Labor Standards did not violate the Sunshine Ordinance. And then we received a request on April 28th for additional documents. We didn't know that anything had changed, but we're inclined to think that something had changed when we received a new request. We did check court documents and did realize on April 26th that actually the judge had made a preliminary approval. So based on that, our office made those documents available to the complainant here tonight, just so people are aware of the timeline, and that is consistent, I think, with all the remarks that were made previously. With regard to class counsel indicating that they did not request that we retain this, the shared information agreement is between the city attorney's office and class counsel, not directly with our office. So interaction with them was mostly or almost exclusively through the city attorney's office. It was my understanding at that time they did not want it available. That's not something I didn't offer. That was in response to a question from the task force. It was my understanding then they did not want it made available. It certainly made sense that they would not want it available at that time because they were concerned that there was interest in undermining or even blowing up the settlement terms. If I can make, and I think it's important before this body, this is for final approval a week from tomorrow before the same judge, that there are in the neighborhood of 1,700 members, potential beneficiaries of the settlement terms. Not a single member has objected, and there's actually only one objection to the case, and is the complainant before you today, who has not been an employee of this organization with the Archdiocese of San Francisco, nor do I believe that he officially represents any of the individuals who are potentially beneficiaries in this settlement agreement. And then I'm available for any questions.
Thank you.
I have an order of process here. I usually, as the chair, it's my prerogative to scan create the agenda, and I scan the cases to make sure that they're appropriate and whatnot. And when I read the intake form, usually I start with the intake form and look at the actual complaint, the way it read. Didn't seem like what the petitioner had just made testimony about. The petitioner has asked us to review a previous decision that we made. Okay, that is in what we call a request or a proceeding for reconsideration, and we have a certain time frame that can happen after a case has already been, for sake of a better word, adjudicated, and an order has been made. That said, this would be somewhat of an appeals case to try and overturn a previous decision that we made. So essentially, it's a duplicative complaint. And we have a rule in our complaint procedures not to allow duplicate complaints. People get two bites of the apple, or double jeopardy. And sure, go ahead. Oh, and so I would disallow this case from moving forward, and because it's beyond the time, I think it's 60 days after an order has been made to file for review of consideration. I'm done.
So just clarification on what you just said about the motion or request for reconsideration. That time has passed. And did it pass prior to this document being filed? I don't know. Is there any way for us to treat this as that? I do recall hearing this case. I just fuzzy on the timeline.
Yeah,
so.
it was in April, and it's actually 30 days. It says within 30 days of publication or issuance of the order of determination, either party or may petition the task force for reconsideration.
And when was this filed? I know we're in September, but I don't know if it was actually filed. And
This was filed on May 9th.
Actually, the intake form says October 25th.
I know, but the first, at least if we take Peggy at her word, which maybe we
Cheryl.
No, Peggy. I don't know who Peggy is exactly.
Miss O'Donnell.
Ms. O'Donnell, standing up in the back.
The email is signed Peggy. So your email on
what page?
1 second. Page 502. The email that's dated August 25th says on the second paragraph, on May 9th, 2019, when I submitted my request for reconsideration of task force findings, file number 18081, I attached 4 important documents that need to be considered and included in the agenda packet. Cheryl, was there an original form submitted in May?
I believe there was.
So I think that addresses the timeliness issue.
Why isn't that in the?
Everything that I have been given has been provided in the file. I marked all the appeal documents to be first, and then the complainant's supporting documents and the respondent's supporting documents.
Yeah, but where's for this particular case today, where is the intake form for that?
You talking about the summary?
No, I'm talking about the intake form. Like, how did they make the complaint? The complaint form.
Complaint form, yeah.
Yeah, where's that?
She just sent me an email.
Okay, so that should have been at the top, because I'm reading what's at the top of the agenda is a intake form, a complaint form from October 25th, 2018.
That was the original complaint.
Okay, so that's not for this. That's not for this complaint.
No, this is the appeal. There was no complaint.
Right. We
form
don't do
filed.
appeals unless it's within 30 days of when that decision was made. And that the decision that for this case was made in April 3rd. So there's no, we call it reconsideration. So there's no, but it wasn't filed within the period of time.
What was the date in May?
It was May 9th is when the email asking for reconsideration was first sent, which doesn't seem to be in the packet, which is still not within 30 days, but we're getting close. It's 34 days.
Well, that's a different question. I mean, that should have triggered for someone to be contacted at that point. Yeah, because we don't do appeals. We do reconsideration, which is the same thing, but it's within 30 days, and this is beyond 30 days.
Well, but so we're talking May 9th, though, not the.
If the task force wants to waive their own procedure for this particular case, a motion has to be made for that.
Absolutely, I'm just wanting us to recognize that the dates are April 5th to May 9th, not August 16th.
April 3rd. April 3rd is when the decision for the ordinance, for the order determination, it's April 3rd. It's at the very top.
Okay.
Yes.
Yes.
There was no determination posted, and I contacted.
Come up to the microphone.
So after the hearing, because of the testimony that Mr. Mulligan provided, we contacted class counsel and found out that what he had communicated to the SOTF did not agree with what class counsel said. So then I contacted Cheryl to find, no determination was ever posted until I sent an email asking about the procedure for submitting a reconsideration request, was told the procedure, told it that I had time, and then they posted a determination. So what date was the determination posted? Because that's posted on the website. And so it was less than 30 days. And then it was scheduled to come here for a hearing, but Mr. Mulligan was not available to attend the hearing when it was originally scheduled. Then Mr. Tucker and I, we were both away in the summer. We couldn't be here, so we asked the first date that it was possible was going to be today, September.
Yeah, so let me just go back to what our procedure for reconsideration says. It says within 30 days of publication / issuance. So that slash means what? And or, right? So what does issuance mean in this sense? Does that mean? Go ahead.
I have a question. Cheryl, do you typically email out a copy of the order of determination to the parties?
The parties, yeah.
What day did you email it out to them?
I don't know.
To me, that would speak to your point about issuance. Even if it wasn't necessarily posted, that would have been issued to them. So if that wasn't the same day, obviously, I'm assuming you didn't email it the date we met.
We didn't get it until after I because I wondered, and it never got posted. We never received it. And so then I contacted to find out.
Well, that's why I'm asking what the word issuance means, in this state.
I think Member Cade has something he wanted to say, and then we'll hear from you in a second.
Yeah, I remember this from the complaint committee. I wasn't here for the full task force. It seems like since the task force met on this, the settlement agreement has been produced. I actually have some issues and questions with the settlement agreement, and based on what I understood the situation to be in the fall. And so I understand the procedures. I think we're all here. We've got the material in front of us. And so I believe that we typically ought to follow the procedures and requirements for reconsideration. But I also think that there's possibly grounds for a new complaint, and I would rather conserve everyone's time and energy rather than having the complainants file a new motion based on at least what I think are new facts that post-date the task force hearing. And so I would make a motion that we suspend the rules and consider this reconsideration request.
I'll second that.
So you're okay, waiving the rules. Go ahead.
I just seconded it. Is there any public comment on the motion to waive the time rules and allow this reconsideration? Seeing none, go ahead and call.
Okay, so go ahead. Sorry, go ahead.
Go ahead and call the roll.
Member Kate?
Aye.
Member Kate, aye. Member Wolf?
Aye.
Or Chair Wolf, sorry. Member Yankee?
Aye.
Member Yankee, aye. Member Martin?
Aye.
Member Martin, aye. Member Tesfaye?
Aye.
Member Tesfaye, aye. Member Kanata?
Aye.
Member Kanata, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Member Highland, absent. Member Wolf?
Wait, that's
Aye.
you. All right, so as Member Wolf pointed out, we have a special procedure for reconsideration, which we are now entering now that we've waived those rules.
So I'm going to read it because I'm sure that's not in front of everybody. So it's in our complaint procedure D under reconsideration of task force findings, paragraph 3, reconsideration hearing procedure. A, if a request for reconsideration is granted, the complaint will be scheduled for a hearing at the next available SOTF meeting. B, the SOTF's previous vote to find violation shall be considered rescinded with a vote pending action. C, the requester of the reconsideration shall be provided 5 minutes to provide testimony as to how the new information provided will affect the decision of the SOTF. D, the opposing parties will be provided 5 minutes to provide testimony regarding the new information provided. Note, testimony should be limited to the submitted new information. E, the SOTF may perform one of the following actions based upon the new information submitted by the petitioner. Sub I, move to revote on the original motion without changes. Sub I, move to substitute a motion with a different action. F, accept public comment on the motion. G, SOTF votes on the motion. H, if the actions of the SOTF changes, a revised order of determination will be issued. And additional orders of determination will not be issued by the SOTF if their decision is unchanged. So the litmus or the trigger for reconsideration is if there's new information, and the information has to be substantive. So that in order to approve for anything for reconsideration, that has to be determined first.
You read from?
Sorry? No, this is from our complaint procedure, D under D. So the new information, if new information exists, is relevant and may change the outcome of the complaint. That's the litmus here.
So,
and we should determine that first, because if the new information is not relevant, and we feel that it may not change the outcome of the complaint, then we can deny the reconsideration.
So I believe what that sounds like is the complainant is allotted 5 minutes to explain the new information only. We started with the intro not knowing it was a reconsideration. I understand how we made a misstep there, but I don't know how to walk backwards.
I thought they did present the new information already, and it was rebutted by the respondent. I think all that information is out there already.
I mean, I think you're right, but Member Wolf just outlined a procedure asking us to follow it.
Yeah,
I'm not sure whether we retroactively can say we did.
But I think, when we after public comment, and if there's an opportunity to make a motion, I think we could do it at that time too, because the outcome is either we approve that there be changes to the order of determination based upon the new information, or we don't. And then at that time, we can kind of consider whether the information is valid or not. Or you could do that now. It's up to the body. You can make that determination based upon the testimony of the petitioner that this is new information, whether this new information pulls the trigger or trips the threshold, or
But just
whatever the appropriate
just on the
hyperbole
petitioner's
is.
info or on the response?
No, not the respondent. It's the first they have to provide how the new information, it says it, the requester of the reconsideration shall be provided 5 minutes to provide testimony as to how the new information provided will affect the decision of the SOTF. Then the opposing parties will be provided 5 minutes to provide testimony only regarding the new information. Has to be only on the new information, okay? Then the SOTF may perform one of the following actions: move to revote on the original motion without changes, or move to substitute a motion with a different action. So we can just continue with the procedure.
So, I mean, if we take what we heard in the first 5 minutes, or the 5 minutes from the complainant as meeting that requirement, what I'm hearing is that it's not so much a matter of new information that's changed the situation, but that the case has actually progressed between now and then, and now it's a different situation, which isn't a matter of reconsideration. So that's where I'm leaning right now, and I'm curious what other people think.
Well, and I'm sure they'll let me know if I'm wrong, but I think the complainant is saying respondent made statements during the previous meeting of the task force in April that in their determination were not true, and that they think that that's a material change and could have altered how we decided things.
But we need to see that evidence.
Right. I think so. The evidence they have is they're presenting what they think they have is material change in Mr. Mulligan's statements to this task force in April versus what the class action attorney told them via email. Whether it would have changed the outcome of the hearing, I'm not going to say, but I think that that's the assertion of what they're putting forward.
If someone has a question for you, but
Actually, I have a question. I do have a question for you. It looks like subsequent to our hearing that you received a copy of the settlement agreement. Are there other documents from our hearing back then that you're still waiting to receive? Are there still other outstanding documents that you want? Or are you asking us to basically go back and say, we shouldn't have ruled the way we did back then, but...
That.
Okay, so it's not like there's other outstanding documents that still have to be...
No,
okay.
Certainly not for the purposes of this hearing.
Okay, so you do have what you want. It's just...
The real new information is the settlement agreement, because it tells a story different from what Mr. Mulligan just said, for example.
Is it in our record?
Yes.
On what page? Do you know?
I hope you can take it out right now and look at it.
551.
Thank you.
And if you all are pulling it up, if I may, I mean, my recollection, and again, I wasn't here for the April 3rd meeting, so I don't know what was discussed then. My recollection was that the OLSC said this settlement agreement between us and the Archdiocese is contingent on the class action settlement in SF Superior. And there were some issues about, well, if it's not final, there's some still pending discussions, and once that class action, because of the contingent nature of the OLSC's agreement, once the class action settlement was approved by the court, then OLSC would turn over the settlement agreement, and that's what happened. In fact, I think even the day of, 2 days later, I'm looking at the docket of the class action case, the court issued its order approving preliminary approval of the class action settlement. 2 days later, it looks like from the timeline that's in 601 of our packet, Ms. O'Donnell received the settlement agreement. That's at 551. And so that happened after the task force meeting. That happened after the court's approval, which is consistent with my understanding of what OLSC said. And I guess one of the reasons why I wanted to kind of open this back up is because having looked at the settlement agreement, I'm not entirely, the settlement agreement doesn't make it clear that it's contingent on the class action settlement being approved. The settlement agreement was signed September 21st, 2018, and that doesn't necessarily mean it wasn't contingent. It's just there's no language that I see in the settlement agreement that makes it contingent. And I don't know how much that was discussed at the full task force. I know at the complaint committee, at least in terms of me, that contingent nature was important, at least in terms of, I guess, moving it on up to the full task force. And so as far as I'm seeing it, what ought to be a question for us to consider is, one, whether the settlement agreement is actually contingent on the class action approval, and then two, whether, even if it's not, was there a justification for withholding the document that, I guess, wasn't discussed or at the task force?
I have to, may I?
Yeah.
I think part of our, the litmus for this is to determine whether this new information will change the original order of termination.
Right.
So how will it change it?
Well, I mean, again, I don't know the rationale for the April 3rd vote by the full task force. Probably had I been here and I heard and believed, because I hadn't seen the settlement agreement, that the settlement agreement was contingent upon the class action settlement approval, I probably would have agreed and found no violation. It's a different question if, in fact, the settlement agreement is not contingent on the class action settlement. What are the justifications for withholding? And do they justify the withholding, and should there have been a violation?
So I've got, go ahead.
Would that information be in the agreement that it was contingent?
It should have been if it was actually contingent. And I think that's one of the questions I may have is what kind of, because typically you want to make, in other contexts you will do settlement agreements that are contingent upon other events happening. Sometimes it's contingent on the court approving your own settlement agreement because I won't get into the details, but you can ask the court to approve your settlement agreement, and until the court approves it, you're saying it's conditioned on that, and that happens.
So, Mr. Mulligan, can you come up?
Sure.
Two questions. One, as Member Cade alluded to, was this settlement agreement conditionable? Can you use the language for me?
The contingency on the class action settlement approval, where is that?
Yeah, I mean, good question. And in hindsight, it should have been more explicit, but it is contingent on the settlement. The only thing I can really point to is item number 1, and that speaks to the first item of this agreement, that what part of it is to settle in full all the restitution to all of the employees in the class action case. So that's not going to happen until potentially if it gets final approval next Thursday before a judge. So you're right, it should be more explicit. I apologize for that, but it is contingent. We wouldn't agree to any terms outside of that.
What terms, sorry if I may, what terms would have changed, or what obligations on behalf of the OLSC would have been changed had Judge Masulo said no on the class action, I need to see other things, or if she doesn't approve it this week? What are the conditions that would be different?
We start over from ground one. And that was my point I think I made at the prior hearing, is why this wasn't a settled case matter for us. Even though we had tentative terms, it was contingent on this class action case. At the time, we had not even had, and we're peripheral to this case, keep in mind, but there had not even been preliminary approval. At the time, from our position, the whole thing could fall apart, and then we're coming in trying to renegotiate final terms. We'd already negotiated some preliminary terms. There was an uncontested portion of our original notice of violation going back 2 years for $1.4 million. That was uncontested. There was a balance of the workers that was in question, and then that's what was ultimately picked up by this class action case.
Were there any communications with the Archdiocese and OLSC kind of, I don't say cementing, but putting this agreement in writing in emails, that whether, because it's not as explicit in the agreement itself, but often, there may be, as maybe drafts get kicked back and forth, that, is there, not saying I don't believe you, because I think what's happened is consistent with that, the fact that it was produced 2 days after preliminary approval, although it's only preliminarily approved.
If I can offer for that, because officially under our investigative privilege, we would hold the right until final approval. That being said, to support the class action settlement, that is the disclosure period. And we had a conversation within our office because we do have concern about precedent. But in the class action settlement, that is the disclosure period. The class is providing all documents. We wanted any of the potential beneficiaries from the settlement to have the benefit of our audit process as well, so that it's all potentially made public, so that there's no potential conspiracy theories or arguments about what the Office of Labor Standards role may have been. So that was an internal decision around that. But good question.
And when did, and I know that there's some new material in the record in front of us today about plaintiff's counsel in the class action, but when did the class counsel see this September 2018 executed settlement agreement?
You know what? I don't know the answer to that.
So one last question about those documents, though. On pages 556 and 557, those are the 2 pages that are the signature lines. Mm-hmm. There's a couple lines missing that haven't been signed, and I just want to understand whether that's because they were signed by those parties later, or I'm just not reading the contract right, or...
Yeah, your signature is not on it.
Yeah, I don't have an answer for that. That was the document that we had. I believe all the signatures...
Did you sign it?
The signatures are all in place.
Yeah, they're there.
Yes.
No, but his signature is not.
It's weird. There's 2 signature pages, and one is missing Mr. Mulligan's signature and the other is missing the church's signature.
I think what happened is that it got handed around. So there was multiple copies, but they all ultimately bore all signatures.
So,
That's
right,
not
there's
uncommon.
there's actually a clause on the page that says the agreement may be signed in counterparts, each of which constitute. I was just wanting some contextual understanding of what I was looking at, and we got that. Where I'm at, it sounds like, although this document was mostly finalized to the point that we heard from the complainant in April, it hadn't worked through its process where you felt that it was no longer an active document under the exemptions to be turned over. I'm hearing things that seem to explain how all these pieces worked, and based on what I've heard, I'm not hearing a reason to continue with the reconsideration, although obviously that would be.
So is this the document that was missing?
This was the request, I think, where the complaint was filed.
And when did this appear?
If I can direct you towards the timeline.
Okay.
So on the timeline, under the highlighted in yellow, you can see April 3rd was the date of the hearing. Then April 26th was actually when the judge made preliminary approval. The 28th is when we received a new request, unaware of the court action on the 26th. And then on the 30th, the document was provided. As you can see on the right side, the date and content of response.
Okay. Okay. So, Chair Wolf, Josh Wolf.
May I ask one clarifying question? Within the settlement document, which section were you pointing to again that alludes to?
The only one is, if you look at the parties agree as follows, item number 1. So the first item is for them to settle out all of the restitution provisions, and those are provided in the class action case. So the class action case...
I'm having great difficulty finding this. What page?
Page 552.
Okay.
I'm sorry. Yeah.
Okay. Thank you.
Yeah. Yeah, sorry. Page 2.
Yeah, we got it.
So that's item 1. And again, it's not as explicit as it should be. In hindsight, that's very clear. But the first item under the parties agree as follows is the restitution, which is actually provided for in the class action settlement.
So that Thayer and Al versus the Archdiocese is the class action?
Yes.
Okay. Thank you.
All right. Is there...
Yeah. So, Mr. Tucker, I have a question. So are you claiming that the settlement agreement is the kind of missing document that you didn't receive? Because your original request was failing to respond to a request for litigation documents in a timely and complete manner.
We wanted to get this from the OLSC, and they specifically did not want to give it to us, and that's what you said was okay last March or April. This document.
Okay. All right. So, Chair Wolf, Josh Wolf, I'm trying to understand why this wouldn't be applicable and change our determination.
Why it wouldn't be?
Yeah. You're saying that it doesn't rise to reconsideration.
I mean, in essence, when they asked for the document, the Office of Labor Standards opinion was that until this document has been approved by the court, it is part of an active case file and is protected for that reason. The reason that we ruled that there wasn't a violation is we found that it was part of an active case file. Even though the document itself was signed in September of last year, it wasn't until the court itself signed off on it that it went from active to a historical court document. And in fact, I think you could make an argument that it still isn't really, it's still a draft document until the final ruling by the court, although we're in this interesting position where they did decide to turn it over in this interim period. I think that Like, we heard the arguments about how this was a draft document in April. The arguments that it was a draft document in April haven't been overcome by the fact that the agreement was signed in September. The evidence that it wasn't a draft is that it was signed in September. And so for these reasons, I'm not convinced that there is evidence that we made the wrong call.
So then I have another question. The respondent's reason for not disclosing it was based upon investigative privilege. Is a settlement agreement investigative information?
I mean, I think there's a different exemption for a draft settlement agreement that they could have used instead. So maybe.
Yeah, but we're not here to make the case for.
No,
for any party.
I hear that, but we're in a reconsideration situation.
I know, but the point is, we're reconsidering based upon our order of determination, based upon the testimony that was provided to us.
But based on only new evidence.
Based upon only new evidence, but it's also based upon whether this new evidence was part of their defense. Their defense was that it was protected, claiming that investigative privilege in response to a request as provided by California Evidence Code sections 1040, 1041, California Government Code sections 6254 and 6276. So they're claiming that this document was part of an investigative file.
And we decided against that claim the last time, and the new evidence is saying that the agreement was not contingent upon the class action suit. And to me, the first line of the agreement says it's contingent on that being signed. So I agree with what Sitting Chair Wolf previously said. I don't see that this would change my.
I mean, it sounds like perhaps an ongoing negotiation instead of an active investigation is really the exception that should have been invoked. But other than that, I'm not seeing anything.
Right. So that's the point, though. We have to interpret whatever the defense is appropriately. If they were to apply it under a different section of law and that wasn't their defense, it's not up to us to make their case.
I agree, except for because it's a reconsideration.
But that's the point I'm trying to say, is you're making the case for not making, it sounds like you're trying to expand, what it could or should be under some other area of law, and that doesn't affect the substance of the reconsideration. I'm trying to figure out if their defense in saying they didn't want to release this, if this document is not based upon what their citation of the law is for withholding it, then they're in violation.
I mean, except that I think that if this document rightfully was withheld until the judge approved it.
That's what I'm trying to determine.
You're interrupting.
I'm sorry.
If the document was rightfully withheld until the judge signed off on it, and they used the wrong reason for withholding it, I don't think that, because at the end you do the reconsideration and you decide you hold them in violation for using the wrong reason. Like, whether it's withheld for an active negotiation or an active investigation, it's still lawfully withheld, and I just don't understand.
I completely disagree with that. I think every court would too. No court would say, "Oh, well, they said this is their defense that they applied," okay, and their application based upon the new evidence was that new evidence doesn't apply to what their defense is. I'm not going.
But the generic reason why it was withheld is that it's an active document that we can't withhold until it's done.
No, it was because it was part of. They were claiming investigative privilege. That's why they're withholding it, and that the ordinance requires them, if they're going to withhold it, to cite law, and the law that they cited was based upon investigative privilege.
Okay,
it's our determination. To determine whether this settlement agreement that shows up before us, it actually is applicable based upon their defense. And if it's not, then then they cited a wrong one, didn't correct it here, based upon if they corrected it here and said it wasn't released under a different section of law, then we could reconsider that. It's not up to us to make it generic and for it to be.
I agree. I just am concerned that if we go through the reconsideration process, we still end up with the fact that it was lawfully withheld.
Go ahead.
But I think when we look at the order of determination, I mean, it cites 67.24, right? B, litigation material. 2. And it says, unless otherwise privileged, records, all communication between the department and the adverse party shall be subject to disclosure, including the text and terms of any settlement. But they're saying, that's what they're saying. It's not, they're not going to release it. I don't see the investigatory portion that's used to.
6724 pertains to both investigation and litigation.
And I recall talking about the litigation material is what I thought the thrust and the crux of that was, because we're talking about a settlement document, and why aren't they producing the settlement document? I think if you went back, we're talking about litigation material, not investigatory.
I mean, I think that there's a fairly high chance that, at least in the verbal conversation, the words active investigation were used when they really meant active litigation. I just don't know whether we want to make a deal out of that.
Well, if I may, I think the only thing, and I guess I'm the one who got this started, but I think the only thing that's different from what you all had in front of you factually, and you know, different facts could lead to a different outcome based on the provisions of the ordinance, but the only difference is that we now have in front of us the language of the settlement agreement, which barely, but does make it contingent on the class action approval, which was the part of the discussion, I understand, in April 3rd. And I mean, so nothing factually is any different than it was. It's just now we have confirmation, whereas before we did not.
Okay, so so under as was noted, under 6724B2, unless otherwise privileged under California law when litigation is finally adjudicated or otherwise settled, records of all communications between the department and the adverse party shall be subject to disclosure, including the text and terms of any settlement. Okay, we're talking about a settlement here. Here's
and it was
here's
turned over once it was.
Right. So so Mr. Tucker, when was the document presented to you?
Which document?
The document that you're concerned about. That's why we're here.
April 3rd.
April 3rd?
April 3rd.
30.
You mean the settlement?
It's on
April
601 on the.
April 3rd. Did you receive it on April 30th?
Around that time?
Because that's our original order of determination was to find no violation under this section. Okay. The question now is, now that it's been produced, was it timely?
Well, timely in what sense? We were happy to have it when we got it.
When did you get it?
April 30th.
The timeline said it was signed April 20th.
No, not when it was signed. When
April 30th.
Yeah, okay.
You read number 2.
Got it. Okay.
So it was signed April 26th.
I can't. It's hard for me to read on here.
It was signed April 26th, I believe, and they received it April 30th.
Okay.
And the request was made April 28th, which is a Sunday, so it was an immediate disclosure request that was done the next
But
business
that's
day.
not what we're talking about. We're not talking about that immediate disclosure request.
I know, but
Okay.
that would be the next place we could end up.
Okay. I got it. Okay. I agree with you now.
Okay. So, is there a motion? Well, we need to. Do we get to hear closing? Let's hear from Mr. Tucker because he's got some stuff he wants to say, and then we'll give.
Then it's we allow testimony from both the parties then we make a motion, then take public comment on the motion, and then we vote. That's the way the procedure is supposed to go. There's no rebuttal.
Okay.
Haven't we heard from both parties?
Because the point here is whether to, is just to determine whether we should change the outcome or not. We've already heard plenty of testimony on this.
All right. I'm sorry, sir. I guess our process doesn't allow for a closing remarks.
Unless the body wants it, you can
well,
overrule your own.
I'm going to make a motion that we do not consider this for reconsideration.
I will second that motion. Is there any public comment on the motion to not consider?
So it's a revote. Basically, once we take this on reconsideration, it's as if we're back to the point just before the vote of the.
So the motion would be to vote on the original,
revote
on the
original motion.
And could somebody read that original motion?
Without changes, yes.
The original motion was miswritten in the notes, I think.
Yeah, I've got it. It's on.
Move to affirm the task force vote of April 3rd on this complaint.
Yeah, I can read it to you. The motion is, where is it here? I think it's on 479. Based on the testimony evidence presented, the task force found the Office of Labor Standards Enforcement, the respondent, did not violate Administrative Code Sunshine Ordinance Section 6724B2.
That's my motion.
I'll second. Is there any public comment on that?
Just revote. We don't need to do a motion. We
still have to get public comment on that.
Yeah, you just still need public comment. Is there any public for comment on this?
Seeing
she's
not a party. Peggy, you can go ahead and
You are party,
speak
so
and
not public comment. You had your testimony time.
Okay, so at the original hearing.
Can you pull the microphone closer to you?
At the original hearing, our
Closer.
complaint was that we did not receive the document in a timely manner. And there was a lot of discussion about whether it was a litigation document or an investigative document. And so it came down to, I forget which member, I mean, I listened to it on the tape, but saying, is the Archdiocese adamant that you do not share the settlement agreement with the class action? And Mr. Mulligan said, no, the Archdiocese, no, like it wasn't them. It's the firm representing the class is adamant about that. And then somebody on the committee said the attorneys of the class, like representing the class, don't want you to disclose the tentative settlement. And his response was correct. So those two statements were false. It was not it was not the attorney for the class, and it was not the judge who wanted this information withheld. The class members need to make a decision about whether to opt out or to go with the settlement. If they're to opt out, this is their backup, nothing. So if they have a closed door at the OLSE, if the settlement is agreed upon between the Archdiocese and the class. So even if it's an unfair settlement, even if they're not even going to get, I mean, the OLSE is responsible. Their job is to get every employee who is owed money that was withheld unlawfully by the Archdiocese to get them 100% of what they were owed. They didn't do that. They were incapable of doing that, which is why the case went to a private attorney. And now the attorney is trying to settle the case, and the OLSE is not letting the class members have access to a secret settlement that they've worked out with the Archdiocese that hugely affects what the outcome will be for them personally if the class action is settled. Do you have questions? Does that make sense? And if it's true that it's
there's no clock running.
litigation and it can't be released, he shouldn't have released it now. So that's right there. He's So anyway,
Great. Thank you.
Thank you. Okay, let's vote.
Right,
Any other public comment? Seeing none?
I
ahead.
just have a comment about the public comment. Before it's finally settled, any settlement, under our section of law, under 6724B2, everything can be withheld unless unless California law, unless there's some other law under the state law allows for the release of that information. I think what I'm hearing here, though, is that the attorneys for the class was not releasing the information to the class members. And that's really a situation between those two parties and not necessarily between the city government and them. Am I getting that right?
Well, I think what they're actually alleging is the opposite, that the city attorney came here, or sorry, the OLSC, and said, no, it's the civil attorney that's not producing, that doesn't want the civil settlement or the settlement produced. And they later followed up with the civil class action attorney, and he said that's not true. And that is, I think, what the impetus was for the reconsideration. And those are agreed. That sounds egregious, and it may be. And I think he spoke to that today and regrets saying it. But does that change the determination of the settlement being considered a pre-litigation or litigation document not subject to disclosure? And that's what we're deciding. So, it sounds terribly, and you're right, you confirmed, because I looked in the materials with the civil attorney, and I think you said you tend to believe his stance that he wasn't withholding it. But does that change the nature of the document and the applicability of the ordinance in this situation?
All right. Go ahead and call the roll.
So an aye vote upholds the last decision, right? So just so everybody's clear.
That's right. There are no changes.
Right.
Right. So I is status quo.
Yes.
Yes. Cheryl?
Yeah. Member Kanata?
Aye.
Member Kanata, aye. Member Wolf, or Chair Wolf?
Aye.
Chair Wolf, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Martin?
Aye.
Member Martin, aye. Member Tesfaye?
Aye.
Member Tesfaye, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Kate? Member Kate, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Member Martin, absent. Bruce Wolf?
Aye.
Member Highland absent.
All
Yeah.
right.
That's what I
Sounded
said.
like Martin.
No, Member Highland's absent, yeah.
Next item.
Item number 11, file number 1905A, complaint filed by Robert M. Smith against the Fine Arts Museums of San Francisco for allegedly violating Administrative Code Section 6725 by failing to respond to an immediate disclosure request in a timely and/or complete manner.
Let me just make sure this is working.
Was this at complaints? Is that where this was at?
This was,
So do we have any input from complaints?
you can just read it into the record if you want.
I think Mr. Smith was before us towards the end of July, and he had, he said the museum invoked an extension of time to respond to the IDR. He says the documents provided were also located on the museum's website. He said this involved the privilege log, whether they are required to provide the privilege log. This was also about how they, and Chair Wolf, you might remember about the slate of candidates on the minutes, if co-fam or fam were going to fill those spots on the board and the minutes, and they were blank. How were they going to be placed? That's what I mainly remember, Mr. Smith, from that complaint committee. Is that correct? You can tell me if I passed.
Yeah, it's
okay.
there's a bit more, but you have it right. Look, I'm here today for two reasons. One, to get the documents I and any other member of the public is entitled to, and to show you beyond doubt, really, any doubt, that the museums are acting intentionally in violating the law. You're dealing with a scofflaw, a city department that has chosen to act illegally. And I guarantee you that you'll have no doubt of that in the next 2 minutes or whatever I've got here, 3 minutes. So first, here was the request. You'll note that it's an IDR, and it was on June 5th of this year. So I bizarrely, put yourself in my shoes for just an instant, please. I received nothing from that was generated by Ms. Wilsey in any way that I know of, saying I resign. The museum's position is there's nothing that says that this woman, this chair, I suppose, resigned. It's extraordinary, isn't it? Even if she didn't turn in a letter, wouldn't somebody have made a memo of a conversation, something, saying she quits? I've gotten nothing saying that, and I've told them so. So there, here it is. Just so I'm documenting myself as I go. It says, you've shown me nothing that says she quit, which is really beyond credible. Then the museums, even now, after all that we collectively have been through, ignore all statutory deadlines and make up their own deadlines. For example, sorry, I'm not, I hope you can see this better than we can see it here. But this says that they are invoking, this was an IDR, they're invoking the extension of time to consult with another interested agency, and they know I'm going to ask them because I did before, what's the other agency? I have a right to know. Guess what the other agency is? They're lawyers. The city attorney's office. How can this statute never was meant to provide extra time to talk to your lawyer? And that's what's going on here. In addition to which, it's been more than a month. I say, hey, it's more than a month. They say, nothing. Then I say, what is their standard? Well, they've made one up. And I'm not kidding. Here it is in their correspondence. And their standard is as soon as reasonably possible. Forget the act. Forget freedom of information. We'll do it when we find it to be reasonably possible. Can you believe that? And I won't show you more that say the same thing. Let's go on to redactions, the issue of redactions, which we've been on, which we've talked about in the past, and they're well aware. And they are guided, they say, by whom? By the city attorney's office. So it's not as if they don't have any knowledge of this stuff. In any event, redactions. Here's a redaction. Privacy, email, okay. But who are these people who are copied on this email whose names they've simply blacked out? And for what possible reason? None is given. For example, here's another one. Okay, I get that they may want to take out emails. Why are they taking out the names of recipients, for Pete's sake? It's not allowed. Under what basis? Remember, city attorney is advising. They are next. This is the most remarkable thing, and I suggest to you it has great importance for you as a body. They are withholding documents without identifying them.
I'm sorry, I can't read this.
Oh, sorry.
And is it in? I'm sorry. Stop his time. I'm just wondering. Can you reference where this document is? I mean, is it in our records, or is this something new?
No, this is something I'm just
showing, but yeah, I guess it is in your records because they have been ordered to give everything to Cheryl. So yes, it is. Where it is in your records, I don't know. But I just pulled out copies so I'd be able to show them to you.
Restart his time, please. Thank you.
I'm sorry you can't read it, but basically it says they've withheld records and they haven't identified those records. So I'm in the position of this remarkable state where they've kept stuff from me and they don't identify what it is. So how can you possibly act on that? Will you please make a determination that they have again willfully, intentionally violated the law? And would you please refer the matter to the district attorney? That collectively now, we certainly have arrived there. There can no longer be any question about intent or what they have done. These documents speak for themselves. It is impermissible, finally, to say we're withholding documents and we're not going to tell you what they are.
Thank you, Mr. Smith. All right, the city has 5 minutes.
Any persons or witnesses?
Any persons or witnesses on behalf of the complainant? Seeing none. All right, the city has 5 minutes to respond.
Hello, Melissa Powers and Megan Bourne on behalf of the Fine Arts Museums. I guess I'll take a couple of points. I think the summary of our original timeline was in our input for the complaint committee, and that's on page 660. So we don't necessarily dispute the fact that we went beyond the timeline of the IDR. If the scope of this complaint is just 67.25B, that we were beyond an IDR's time frame, then we've never disputed that. I don't really know what his last item was in terms of withholding, and I'm not telling you what they are. Those redactions he showed you, we didn't redact any names. Some of the people's emails was literally, that's what it was. It was from their personal email. It didn't have a name. We know to give a name when the name is there, and then, so if somebody's email is blank with blank, it's their personal email, that's what we redacted. So I'm not exactly sure with that point. And then we did do a final distribution of documents to Mr. Smith in August. So, we've provided Mr. Smith what we have to provide him, and this is not this big, intentional act, willful act, where we provided him when we could in terms of his making a thing that we're making up legal standards. I mean, if you look at even the language in the statute where it talks about, I think it's in 67.25D, I mean, it uses words like reasonably possible. It's not like I made up the words reasonably possible, which is so outlandish. So that's pretty much what we have on that.
If I might, this is Megan Bourne. If you look at page...
Hold on a second. Can you turn on the other microphone? Cheryl? She has to do it.
Go ahead.
Oh, okay. Yeah. Okay. Where was it? I would just say that we... Mr. Smith says that we've shown nothing that says, from Mrs. Woolsey, I quit. There was nothing to show. So we can't provide something that doesn't exist.
Well, except I will say,
there are minutes from a March meeting, which were in the package, where Mrs. Woolsey announced in a meeting, but she has never submitted a written document.
So page 671 of your packet that Mr. Smith received, Chair Woolsey announced she will retire as president. It was a regular order of business, and that's what happened at that meeting, and that's what there is.
So this is still your time to continue sharing anything that you have to share.
I guess I'll respond to questions as they come up, but that's all we have to offer.
Great. Thank you.
Thank you.
So the initial immediate disclosure request was June 5th. When was the first time you responded?
I responded to him, I think within the time frame to tell him that we were invoking an extension on June 6th. If you look on page 660, that gives you the original timeline that we need to consult with counsel. I understand that there's a disagreement between this office and the city attorney's office as what's an extension, but Mr. Smith and I agreed on the 19th, and I did go back to him on that date and said that we are still conducting our review, and we'll get back to him. And then, I provided him documents when we could, so it wasn't like we went radio silent on him.
Thank you.
I have a question with regards to the redactions. So on page 667, you redact who it was from.
But that was that too was an actual email. It wasn't. So if you see
What
like
about above that?
Yes.
Is that an actual email?
Yes. Yes.
Okay, and then moving to the right, there's a fellow named, it must be his last name, Moment Jason.
Yeah,
and then there's a redaction, and then there's his email address.
Right,
so,
because that's his spouse's name. That's redacted. It's like if you and your spouse have a joint email, and in that particular case, it reflected the spouse's name, so I redacted the spouse's name because that's considered private. But in other cases where, for whatever reason, the spouse's name was not reflected, you got the full Jason Moment without a redaction.
Okay.
So why are some emails redacted and some aren't?
When we saw a spouse's name, we redacted that. If it wasn't a spouse's name in that, or if the email came across as somebody's, it didn't identify, Bruce Wolf and then your personal email. It just came across as your personal email. I redacted the personal email.
So Jason Moment, that's not his personal email?
That is. The part that is redacted, that's his business email.
Okay.
But what's redacted is his spouse's name. There's other pages where, for whatever reason, his spouse's name was not reflected, and then you would see Jason Moment and then the email without the redaction space.
Okay.
That's it.
Okay, but for Catherine Lasser,
Same thing.
No.
That's her spouse next to the redaction spot. And then
but
you,
there's
No, it's the email that got.
right.
but the whole email is gone.
But that, I'm sorry, in that particular case, a few times it would have Lasser, Catherine, and her spouse. In this particular case, it's only a personal email. She doesn't have a business email. That's a personal, private email.
I have a question. So in the case where there's no name and there's just an email address, is there any obligation to identify whose email address was removed? Because you weren't trying to you weren't trying to hide the person, you were just trying to hide the private email address.
Correct. And I'm not aware of that we need to supplement and create a name on a document that isn't already there. We review it for the item in front of us and we redact it. And
Yeah, but you have to, for us, you have to at least show some sort of evidence of the reason.
well, I think in this particular one it didn't come through, but most of them it was written over it. It would say privacy email. For some reason on those first ones, I think those are the original ones, and I think I told them in an email that when I sent it to him, I don't have that email, that they were redacted for that reason. And then I think in other ones that were given to him, it's wrote over it privacy email. I mean, we're not trying to hide big information here. I mean, if it was someone's private email, we noted on their private email.
Yeah, but the party should at least be revealed.
But if there's no
The only thing you're protecting is the information that could be exploited, not the person.
But if I'm not provided that name on the document, are you saying I'm supposed to type in the name?
Well, at least as part of the reason that you're redacting it, yes.
I'm not sure why it's not reflecting in here, but I otherwise wrote it over at privacy email. I mean, I can go back and email.
I understand that, but could you tell who that was? Do you know who that was?
Well, I know only because I've read them numerous times.
So if you know who it was, then you provide a reason for redacting.
I'm not sure why.
The person should be revealed, at least.
I mean, I'm reviewing it for what do I need to redact? It's a privacy email. Somewhere either in my email to him or in other places where it was overwritten, I wrote privacy email. I've never read that I then have to then translate whose email that is.
Well, right. So if your email doesn't include your name and my email were to just say hi@joshwolf.net and not the parentheses Josh space Wolf part, and you redact the email address, you're left without the name of the person.
No, but you know who the person is. I know it's Josh Wolf. So when somebody asks me,
but then I'd be
hold on. Somebody asks me, please provide me with the names of the people who were involved in this. I see that you redact. There's a name here. You redacted it. Their email address. That's fine. But here I only see a redaction of the email address. Who is that person?
Right, but what if the email is from trustafarian415@gmail.com and they don't know who Trustafarian415 is?
Well, okay. I mean, if they don't know.
But then you asked me to create a record.
Yeah.
I mean, but that's not required of the city department to create a record.
Well, but it's not necessarily creating a record. It's not creating a record. It's information that's missing. That is a reason for redaction. How do we know that is what it is, and it's not some other city department or agency? You redact some things, but you don't redact others. I mean,
I redacted when there was a private email.
I understand that, but I'm not accusing you of anything. But we have, the requirement is to provide a reason for redaction. And if this is going to show people's names and their email addresses, and for the ones that are personal, you're redacting just the email address. When you have one that is just the email address, but you know who the person is, then it should be revealed to the requester.
Why is Jason's last name redacted?
That's his partner's
that's his spouse's name.
In
but
some
why
cases,
would that be redacted?
Because they're claiming that the spouse is not part of the subject matter and shouldn't be revealed publicly. Personal information that's not applicable to the subject matter.
So it's not his business partner, it's his romantic partner is attached to his @route1partners.com email address?
Yeah, my parents, it's Rosalie and Harvey Wolf, and then the email address is hdwrw@sb whatever.
Sure, they
and that's
your share.
And that's how they
for
do
the public record.
That's how they do it. So
I think it's
if my father was the one that's part of the subject matter, then crossing out the spouse would be applicable.
If I may, I think the privacy. I get exactly why you're doing what you're doing, and I think generally it's probably makes sense for people's personal emails. I think what we're getting at is whenever there's no information, I don't think you're required to create a list of who these people who have to be redacted entirely because of the name of their email address. I don't think you have to create a record, as you've said. I do think, though, whenever you have a name like this that has to be an email address that doesn't come with a name, I think probably what might wind up happening is the balancing test of the right to privacy versus the public right to know might, at this point, tip over into disclosure of that email address. I mean, it's.
But then you're asking me to disclose the private email just because maybe they need to know who's behind the email. If it, like we've talked about, if it had my name attached to my private email, he would have gotten my name and then the email redacted.
Right.
But I mean, and just to bring it back to, I mean, and I don't know if this is the way it was printed, but I know that for most of these, I wrote over it the point privacy.
I think I can actually see some of that. It's just a reproduction, I think, in the printouts.
Right.
I do think I've seen that, and I think I saw that in Mr. Smith's, some of his papers. I think, so in terms of privacy, I mean, people certainly, I mean, it's constitutionally enshrined right to privacy. It starts, there's little gradations that kind of start going away whenever you reach out to a publicly available email address, for example, or you're engaging also in conversation with 4 or 5 other people. the notion of privacy starts diminishing a little bit with different steps, right? You're communicating with a public agency, you're communicating then with a public agency in addition to four other people. And so I think that the concern is, especially with regard to when you have to block out an entire address, that is another factor, that there's no name attached to it, that ought to perhaps weigh toward disclosure of that particular email address.
Well, all I can say is when we were doing this and we were doing the redactions, we were interpreting the law as what was required in terms of what you redact as a private email address or not. And, this is, as you all know, I've been here many times, and we've never even discussed like this new tangent. This was a private email. I redacted the private email. He has the substance of the body. I don't know what else to say to it.
Through the chair, to Member Kate, this has been an ongoing issue for many years, right, for us to see things in camera to assure that the redaction is appropriate or not. And we don't have a mechanism. We haven't figured out what a mechanism is that we could do that. Retired judge, the civil grand jury. I've
got no reason to disbelieve that this is just Trustafarian 415 or the equivalent, that it's just a private email address with no other name that would be kind of public otherwise, to which a privacy concern would otherwise attach. I understand and believe that the museums are redacting this for the good faith belief that there are privacy concerns at stake. I'm just saying that the privacy balancing test is kind of a tricky one, and in the context where you've got an email to and from a public agency involving other people who are CC'd, it weighs toward public disclosure of that email address.
So actually, the correct procedure would be for the respondent to provide some section of law that allows for that redaction for that particular kind of information.
I thought they did.
It got blanked out. I guess the question to even to Mr. Smith is, I don't think what he's after is their private emails.
But that's not the point of the intent of what a requester wants their information, public information.
But we didn't the code allows you to redact a private email. This has never
Which
been
code?
The code in terms of the 67, all the rights for exemptions for what you can redact. It's a private email. I've never heard of any other thing than the fact that we can redact a private email when we have one in front of us. And that's what we did. And the way that these were printed, because it was only one reason, we wrote over it, private email, privacy email. So I don't know why it got redacted. I don't know if what you're saying is I have to go back and tell him who the emails were from. But that's what we stand by, these redactions as private emails, and that's all I can say.
Let me just cite some of our code. If you're going to refer to our code, then it's 6724 C, which is personnel information, not personnel. So in city employee information, and under there's C2. The professional biography or curriculum vitae of any employee provided that the home address, home telephone number, social security number, age, marital status of the employee shall be redacted. There's no other, the only other reference is 6725C, which suggests where a record being requested contains information, most of which is exempt from disclosure under the California Public Records Act and this article, Sunshine Ordinance. However, the city attorney or custodian of the record may inform the requester of the nature and the extent of the non-exempt information and inquire as to the requester's purpose for seeking it in order to suggest alternative sources for the information which may involve less redaction or to otherwise prepare a response. So it's kind of two-part. The first part is that it can be exempt from disclosure under the CPRA. So there has to be some citation under the CPRA or the Sunshine Ordinance that emails of this nature can be redacted. And if they are redacted, then the city attorney or the custodian may ask what the intent is for, or the purpose of it in seeking it is for, in order to help them to find other information that may help them with their request, the information that they're trying to request. That may have less redaction. So I'm not seeing how or why this information should be redacted, and I'm not hearing any citations from the California Public Records Act or the Sunshine Ordinance as to the privilege to redact those.
Well, I also know that the Constitution, even the California Constitution, allows for a right to privacy. And I don't think that these private emails would be something that these people would want us to release.
Then to give us a citation under the California Constitution.
I think it's Section 1.
So,
okay, but be it as it may, that isn't your defense here.
I guess
I'm trying to find, because the Sunshine Ordinance requires a respondent, when withholding information, to cite the law that allows it.
I can go back and go back and specifically cite to Mr. Smith the specific citations for redacting private emails. If that's
I've got a question
needed.
for Mr. Smith. All right, 1 second. All right, take your time.
Okay.
So we have, in listening to you and listening to my colleagues, it seems like there's probably 3 issues here. One is there's a timeliness factor, right?
Right.
And we heard from the museum that they acknowledge the timeliness factor. So we got both sides agreeing on that. Let's check that one off. Then the next...
Yeah, one footnote there. That timeliness thing is still going on because I haven't gotten all the documents, but that's
okay,
right.
But
That's
but
right.
there's a violation of timeliness. You suggested it. The other side has mentioned it.
Agreed, right.
Then there's the matter of the documents that you asked for that you haven't received. One of those documents is a written notice about Dee Dee Wilsey stepping down, and it was explained that was done orally, and the only written document is the minutes from that meeting.
I was just trying to give an example. You know, standing outside, you can't see what's in a sealed building.
Absolutely.
It is very difficult to believe that somebody who has been in that position for decades and given millions of dollars and all that sort of thing steps down, and there isn't a considerable amount of memoranda, letters, I don't know what, generated about this seminal event.
I hear you.
Of which I have none, virtually none.
Thank you, Mr. Smith. So you have no documents of that. Are there any documents that you are pretty confident exist that you don't have at this point?
Well, I think the ones I'm sorry, I know I sound cynical or skeptical. I find it extremely difficult to believe that the board chair steps down and the only thing they can give me is a bare bones board of directors record that says, it's a draft actually of the board of directors minutes saying she steps down, let's move on. And to play reporter for just an instant, and I'm not suggesting this is true, but one can't help feel, how can this happen? How can a woman who's given millions and millions and millions of dollars, been there forever, run the joint, step down, and there's nothing generated? Why did she step down?
I mean, it's really not our place to
I know,
assess why she stepped down, although someone from the museum did raise their hand in response to that question, but that's really not the jurisdiction.
I'm not asking you. I'm saying, why am I not seeing any materials relating to what must be a seminal event in the life of the museum?
I hear you, and we've heard testimony from the museum that they've turned over all the documents they possess in relation to that.
No, they. I don't think they've contested that they are still that they still have documents they haven't given me.
Okay, I'll walk back through that with them in 1 second. The final point is this issue of the redaction, which we spent a fair amount of time on, and I want to hear from you how important getting unredacted versions of these documents is to you.
I don't think we have to be. Believe me, I try so hard to abide by your processes.
We don't have to be deaf, dumb, and blind and pretend that there is no context here. There are two other cases in one of which I pressed for Saudi Arabia. Guess what? Documents arrived and they show Saudi contributions to the exhibition. So, but what did they do? They blacked out the values given, they have to be given to the IRS and to the Customs Service, all the values of everything that was supplied. I'm just trying to show you that I don't wish to appear overly journalistically cynical or paranoid. But you see, the Saudi thing is there, but they blacked out all the values now, which a committee has seen, one of your committees. And the second thing is, in terms of redactions you asked me about, on yet the other request, there's a fund called something or other fund. Maybe it's the Wilsey Fund. I can't remember. But there was a disagreement among the curators about the propriety of taking money from that fund and using it for another purpose. So what did they do? They let me see a sentence, and they blacked out the whole discussion.
But
They
in this
redacted that. In this case, yes, I was just trying to give you a context. So if you were in my shoes with that sort of background in hand, having lived through it and experienced it, then you would certainly want to see what it is they're redacting here or know exactly what it is they have redacted here. And you would be very upset, may I respectfully suggest, if they told you they are withholding records and not telling you, not identifying what those records are. That's intolerable by any standard.
Okay, so let me go back one more time to the redactions in this request, which I think there is an argument are unfair redactions. I think there's also an argument that it's pretty clear what these black lines are representative, that it's clear that they're email connected to the to or from of email lines.
Not all of them. I just happened to pull out some examples, and I showed you ones, I guess, haphazardly that relate to names and emails, but there's other material if you look. I couldn't show you everything.
Sure. I mean, I'm just looking at everything that's in our document, and there's a handful of documents, and in this case, every redaction is pertaining to the to or from lines of an email. And so I guess where I'm getting at is trying to figure out where best to put our efforts in order to get what you need. And it sounds like there's this redaction issue, and there's also some more records. So
documents in space.
What's that?
Documents which they haven't and won't identify, which are out there in space but not given to me.
Okay.
They exist. They acknowledge they exist.
Let's walk back through those documents. Thank you, Mr. Smith. If the
can I say just
yes,
one
thing.
further? This may just help you, given everything I've heard earlier in the evening. I asked the city attorney's office. I asked for material that they, since they acknowledged, the museums say they got advice from the city attorney's office. I said, fine, show me the advice, because the statute says I'm entitled to it. There's no privilege. And what happened is the city attorney said, no, there is a privilege, and we're not giving it to you.
Great, thank you. All right.
Wait a second. Before you go, Mr. Tucker. Smith. Sorry.
It's time.
I have a wisdom tooth that's impacted him.
I'm sorry.
Okay, thanks. What you just mentioned really concerns me. You said that there was some documents that were revealed after the Saudi revealed the Saudi involvement or participation, but that the amounts of what they contributed.
The members of the committee saw the blacked out material.
Okay, is that in our? It's not here. Okay. Oh, that's a different case. Oh, okay.
Yes, that's why I said we shouldn't be blind to the context.
Okay. Got it. Okay, never mind.
But have I been clear about what happened?
Yeah.
Right. For the folks from the museum, please. So it appears that Mr. Smith is under the impression there's more documents that relate to this immediate disclosure request that have not been turned over. Is that true?
That's how it appears. I'm sorry.
You're saying
I'm
you're
asking
saying
whether
is
you
it
possess
true?
documents that haven't been turned over that relate to his request, and your response was that's how it appears.
No, I'm sorry. I've misunderstood. I was trying to understand you. We provided all this responsive FAM-SF documents.
So there's no documents that you identified but didn't turn over after consulting with the city attorney or legal counsel?
I don't know what he's referring to when he keeps talking about we told him we're withholding, but we're not telling you. I don't know what he's talking about.
That's irrelevant to the question. Is there any documents that were identified and not disclosed due to any reason at all?
Just in your own research and investigation.
I believe that we've provided all of the FAM-SF documents.
So all the documents in the possession of your organization, because there's FAM-SF, there's like three interlocking organizations, and I don't know who works for what, but all the documents that relate to Dee Dee Wilsey stepping down that are in the possession and access of either of you have been turned over to Mr. Smith, correct?
That which has been deemed as FAM-SF records, because that's the department, and the department is FAM-SF. And we've kind of gone down this rabbit, we've discussed this on numerous and all the different complaints from Mr. Smith, but those that have been deemed FAM-SF city records as the department under the code, the department is the city department, which is FAM-SF. That is what we've provided.
So there could be co-FAM documents, but all the FAM-SF documents have been turned over.
Correct. And I would also point out there's a city attorney memo about this in which this particular matter in which the city attorney recommends that if Mr. Smith believes that there's something that that wasn't provided, he specify what that is.
Yeah, but how's he supposed to know what it is?
I'm just
if it's not being revealed.
I'm just pointing out that was the city attorney recommendation.
Right.
I mean, we are trying to respond in a responsible and legal manner to Mr. Smith's request.
It would be. Excuse me. If you don't mind. If you don't, my concern is with that is if you had a document that was numbered pages and pages were missing. Okay, then you know that there are pages are missing. Or if there was a series of emails and it jumped 3 months or 6 months, what happened in between, and it's obvious from reading the context that there was more discussion, and then it's pretty obvious. But when you have multiple different things happening and there's a whole component that may be missing, but the public has no idea that that element even exists.
But we still have the situation that they acknowledge that they've turned over the FAM-SF documents, but we still have the three interlocking entities and
That's not part of his complaint.
But it is part of his complaint, isn't it?
It references FAM-SF.
Mr. Smith, did you specifically only request from FAM-SF?
Microphone.
Second, folks, I won't read your stuff. I thought you folks made it clear, didn't you, after a lot of digging, that this separation between COFAM, the managerial agency hired with that one paragraph contract that you got, and the museum was completely transparent and impossible. COFAM has the same computer. I don't want to replay the whole thing.
I remember the whole thing, Mr. Smith. My question.
You told them, if I heard it correctly, that they had to produce the materials not just from from the museum, whatever one calls it, FAM, SF, but from the agency actually doing the work on their behalf for whom they're paying. And I'm expecting that those are the materials I'm getting. They can't say FAM, the Fine Arts Museum has nothing because everything resides with the people they hired to keep the files, and you can't have those. That's insane, actually.
You requested both COFAM and FAM-SF, right?
As far as I'm concerned, and you'll notice how careful, and I pointed this out in the correspondence, it is when Ms. Powers responds, and she's the only one who responds, below her name, she has now taken to putting in on behalf of FAMSF. It was a change. So I called her on it and said, why are you putting under your name now on behalf of FAMSF? And I never got really a direct response other than to say, well, that's what I'm doing. If I don't want to go backwards in time here, I believe you told him to turn over those materials. Remember, it was a shared computer.
I do remember that. I want to know what the language you used in your request originally was.
Page 628 is his request.
Doesn't it say Fine Arts Museums of San Francisco or something?
It
At
does,
the bottom
but-
of the letter.
But the bottom of the letter requests request includes all documents herein above described in the possession of and or under the custody and or control of COFAM, Corporation of Fine Arts Museum, and FAMF, the Fine Arts Museum Foundation.
Great. So you did requests from all three, which was what I was trying to verify.
Just trying to be lawyer-like about it. I shouldn't have to do it that way.
I mean, maybe you shouldn't have to.
I
but,
did,
But
yes.
because you did, now let's go back to the museum. And so earlier I asked about documents relating to Ms. Wilsey stepping down that were in possession of COFAM, and you stated that there may be materials related to COFAM, but that you've turned over all of the
SF.
SF, not FAMF. Why was there not a search of documents in COFAM or FAMF's possession relating to Dee Wilsey stepping down?
COFAM and the Fine Arts Museums Foundation are not city agencies. They are private 501c3 corporations.
And Cheryl, how did we rule in this regarding, because this is not the first time we've dealt with this. What was...
And it's never been determined to us. We've never ever seen in any order and COFAM documents.
Just because they're private agencies, they still work with the city department, and you may ask them for information. It's not like you're prohibited from asking them for information. So why wouldn't you ask them for information about this resignation?
We worked with our city attorney on this. We really tried to. I don't have a. I don't think I'm going to.
So it appears that your city attorney told you didn't have to turn them over. Is that true?
We were advised that we turn over FAMSF documents.
And we're back to the other case.
Exactly.
I didn't hear. Did you turn them over or not turn them over?
We did give you some COFAM documents that pertain to it, really trying to meet the spirit of your request. We provided documents from COFAM nominating meetings and from a COFAM executive committee meeting where it showed that, and the reason that Mrs. Wilsey stepped down is because her term expired in June, and so there's a agenda dating back to, I think, October 2018, where it's noted that Mrs. Wilsey's term expires. And then in a March meeting, she announces that she is indeed going to step down.
Yeah, I mean, if you look at what we did give him in the original, I mean, many of these documents are going into COFAM. So, page 677, summary of proposed COFAM bylaws. Page 675, COFAM Nominating Committee Report. Page 671, COFAM Board of Trustees. So
you've given some of the COFAM documents, but earlier I asked whether there were any COFAM documents related to the request that he didn't have, and you didn't say that there weren't. You kind of implied that there were COFAM documents that he hadn't received. I guess the most direct way to ask this is, are you aware of any documents that you identified in COFAM's possession that you decided not to turn over? Because you've already explained that you gave some of the documents in COFAM's possession. So I'm trying to understand if you gave the entirety of the documents that relate to his request that were in COFAM's possession.
I would say we gave the documents that pertain to her position, where her position as the president of FAMSF were discussed, not in reference to her position as the chair of COFAM, which is the private 501c3.
Did she step down from both at the same time?
Yes.
And was it because her term was expiring?
Correct.
And
Well,
for-
her
and for no
term.
oth-
I
but
don't.
did
I mean,
she-
I'm not inside her brain, but her term was expired, and then she.
Did she? How soon before the expiration date did she step down?
She announced in a meeting in March that she was stepping down in June when her term expired.
And that's the official period of time.
Mm-hmm.
Okay.
And if I could, not to go back to a sore subject here, but when I sent Mr. Smith some other documents in past August, because this was not in the packet, is this going to work?
Takes a minute to focus.
It's just showing, I'm trying to show that how we know, how our overlay said, I don't know how.
There it
Oh,
goes.
we can see it.
Yep.
Oh, yeah.
Oh,
yeah.
there it is. Privacy email, like you saw on the previous one. So I think it's just the way that those printed.
And it's been a while since we talked about this specifically. The email addresses or the servers, whether it's for COFAM, the foundation, FAMSF, are they all one server? Or are they separate servers? How are the three separate entities, emails and electronic records, where are they stored?
Well, there are no foundation employees, so it was always coming down to the COFAM, FAMS city employees using the same at FAMSF.org. I can't even remember it right now, but
Right.
yeah.
And so FAMSF is the city agency, right?
Yes.
And
It's the
FAM, yes.
But FAMSF.org, the domain, is actually owned by COFAM, and the server is owned by COFAM.
And we've pointed out also in a couple other meetings, I think I know in previous meetings, it's not in this legal memo, but the whole issue about 12L, I think the threshold is some hundreds of thousands, I'm not sure the exact $100,000 that COFAM would need to receive from the city, and it does not. So when we've talked about 12L.
So there's FAMSF employees and COFAM employees, or those are the same people that work for both entities?
No, there's some people who have dual hats, but for the most part, FAMSF employees are usually like the security guards and some accountants, human resources, and then we have COFAM employees. So, but there are some people who have, two positions.
But all of the computers and stuff you're saying are COFAM's network that is used by the city of San Francisco's employees.
Correct.
So the whole, wait a minute. So the city department's emails are managed by a third party and not by the city's Department of Technology?
Correct.
Is that legal? I don't know.
I
don't know that that's actually legal. I think cities, because they need to back up and keep a retention policy, with regards to that. I should look into that.
Well, and we're looking into how we can separate it as well.
If they're a separate entity, you just go buy their own hosting like they already have. But
we already have done it. I mean, looking into the mechanism of getting the city employees onto the city network and how that would happen.
You should already have like a server of your own, whether it's in somebody's office or in their data center.
They do, but it's COFAM server.
No.
We don't have a city one that we're aware of.
The city sets up an entire server for that department for their use, like where do you save your documents? When you create any of these documents, where do they get saved? They get saved on their server?
On COFAM server.
Yeah.
But it sounds like COFAM and FAMSF don't really have two discrete work environments. They work as a team.
I know, but see, in this case, you know what ends up happening? Somebody requests documents, and they say, "Oh, it's on a private server."
Oh, I realize that
it's not city. It's on city property.
I realize the problem, and I think that the issue is that COFAM realistically, I don't understand how COFAM is not completely under the Sunshine Ordinance in the first place. But this is where we went with the previous case, which has gone to committee, and eventually we'll come back and I'll understand it better. Where I'm at with this case is that there's these COFAM documents that we don't know how many or what they look like that haven't been turned over. There's a timeliness violation that both sides have agreed to. I'm really least concerned about the email addresses being private screened. I think that they may not have made the best case for why those were selected, but I think that we have other issues that are clear violations. I wouldn't be opposed to sending the email redaction to committee, but primarily I'm focused on trying to thread this needle about the FAM-COFAM so that all of the public documents that are rightfully public belong with the public. And I don't know the best path forward to do that other than maybe have compliance and amendments. Is compliance and amendments working on the other one?
It's coming back up here.
Both of them.
So, yeah, maybe this one should get continued till that gets resolved. What are you thinking?
I think we find violations here and do the redaction stuff at the later time. But I mean, there's definite violations here.
Sure. We still need to hear rebuttals, correct?
Sure.
Is everyone ready for rebuttals? Great.
Is that Mr. Smith?
No, you were up first. Mr.
Oh.
Smith gets the last word.
Oh.
Hang on. Go ahead.
I'm not exactly sure what's being found here. I think that if the finding is that we violated the provisions regarding an RDR, understood, and in terms of have we produced the records, I mean, under the code, the department is the city department. We've been to the task force before. We've been to numerous compliance amendments committee. Never in any order of determination or any minutes that I've ever seen the words COFAM records to be produced. I think that issue has never been nailed down by, to be quite frank, this body in terms of what is actually required of FAMSF. So we come in here and then we're told you're not giving COFAM, but we've never been specific, it's never been legally decided what is the authority over COFAM, especially since 12L does not apply to COFAM. So we come in and we provide documents as a city department, and that's what we do. I mean, so I don't, that's, I guess, our rebuttal, and that's really all we have to say.
Great. Thank you.
Thank you.
All right, Mr. Smith.
Let me be plain spoken. I'm hypothetically a city department. I don't like this freedom of information stuff one little bit. So I hire Johnny Jones, just out of school, give him a big bag and say, take all these records. You're working for me now, and you're doing it on a contract basis. Then I get a request. It says, let's have all your stuff. I say, oh, okay, I have very little. He's got it all. And that's what's happening here. You see an attempt to shield a city museum completely by saying, we hire an agency to do all this stuff, and you can't get our stuff because we've given it to them. They're using them as a shield. It's extraordinary, and on its face, it's wrong. The city attorney's office is participating, apparently, according to what I just heard, in this terrible violation. And, for example, I told you about the Saudi stuff finally getting that and then having redacted the value for a reason. You know, they give me I don't know why they gave it to me. The new director of the museum did a brief note for the media and everybody else. It was extraordinary in its brevity. Here's a woman, been there forever, given millions. And what comes out of the director's office, new director? 4 paragraphs or 5, barely saying she did good things. If you were a journalist, I assure you that would raise your suspicions to the sky. Then I'm told that they're going to give me the stuff when it's reasonably possible. Where'd that standard come from? And they tell me that they have more stuff and it's out in space someplace. And then they tell me that they have the right to withhold documents without telling me what those documents are. And finally, I mean, let's just be plain spoken, please. They're saying I shouldn't want this material in a logical, street smart way because Mrs., which is what I guess she prefers to be called, Mrs. Wilsey, she's leaving. Simple reason. Her term is expiring. After giving tens and tens of millions of dollars and constructing a new building and all the rest, she's stepping down because her term is expiring instead of saying, gee, I'd like to serve another 2 years. Come on. Nobody could possibly believe this.
All right. Does anyone feel prepared to make a motion?
Make a motion to find a violation of the IDR request time frame response.
Just the timeliness?
I don't know what other remedy or violation could be found today. I mean, there's a whole COFAM issue that needs to be ferreted out. I mean, that's still not decided, and we've talked about it at multiple hearings. We had the same conversation we had tonight, I think, 2 months ago.
So what is the best way? I mean, the timeliness seems like it's agreed upon. What is the best way to sort of preserve the record on the COFAM thing so that our decisions are aligned?
Sorry, go ahead.
Chair. So the respondent stated that COFAM doesn't fall under 12L because they don't get enough funding from the city to fall under 12L. In that case, who do they fall under? Is it the Sunshine Ordinance because it's not 12L? I mean, I agree with Mr. Smith with the fact that if they're not regulated under something, then any department can go and hire a third party to run the show and deem that that they don't have the records.
I mean, I think it's clear that COFAM is its own thing that needs more digging into. It directly relates to Mr. Smith's other case. My question is more a procedural one. What is the best way to sort of punt on the COFAM while taking action around the timeliness, which is much clearer?
I mean, I think you could just send the COFAM issue to committee on just that. What is COFAM? Does it fall under the Sunshine Ordinance?
Well, I'm just acting chair, so how does our permanent chair feel about that?
I'm permanent?
Or not acting chair.
Lifetime.
And why did you step down?
Explain to me again the premise. I was
the idea would be to find to have a motion around the violation of timeliness, right, which we have a motion for in maybe a second.
I heard that part.
And then to refer the exploration of how COFAM is
right
under our jurisdiction.
You can if you're concerned about whether the other two entities that are contracted with the city are need to comply.
Does our DCA have an opinion on this? On an organization that is contracted by a city department and seemingly is non-regulated?
Yeah, it'd be under 12L.
But they say they're not because they don't get the funding.
Right. I think he might have. I'd have to review it. Yeah.
Off the cuff, I feel like I need to look at the documents that created each of the entities and know really in more detail.
I would like that to be done before this gets to committee, because a committee is not going to make the decision on how they should be regulated. And my gut says they have to be regulated somehow if they're doing business on behalf of a department of the city.
So what is the best process for figuring that out?
Well, I would say, if you're going to apply it to this case and you want, we could take a motion for whatever you want, but if you can leave this case open, if you feel that there's some subsequent motions that you think to be made.
But there has to be some substantive action.
No, I
leave
got
it
that.
open,
That's
right?
what I'm saying. If you need information in order to make some additional substantive the question is that the investigation of that information of the relationship between the corporation and the foundation of the Fine Arts Museums as being independent or separate entities, is it applicable to the decision being made on this case? If it's not, and it's an independent investigation, then, figure it out that way. And then, because we can then dispense with the case, and then, you can take whatever time there is to do that work.
I think it's applicable only because Mr. Smith is still waiting for documents, and it seems obvious that COFAM has documents.
Okay, so are you claiming that it's that information is applicable to this case?
Yes.
Okay, so I would say if you want to start the ball rolling and find a violation, then you can continue this. We don't close the case, you just continue it, and we'll pick it up where we are right now, okay, in this discussion area. And this would be, and then we would, you can bring another motion. You could say, no, we found everything. We don't need to have another motion, and then just declare the case closed at that point.
May I make a suggestion? Is that possible? Just in aid of everybody's time.
Go ahead.
Is it okay?
Sure.
Look, all three cases involve the same fundamental issue. So can't we agree, I thought we had before, that all three cases will, I know you can't combine them or coordinate them or whatever, but can't you hear them all at the same time? Because not only would it save you a lot of time, them a lot of time, me a lot of time, but the issues are the same, and it helps enrich your understanding of what I'm dealing with or what's going on here if you hear all three.
Yeah, we generally try to do that. I'm confused how they're not governed by 12L. They have a $5 million budget.
Well,
we have
it's
to
a matter of,
find that out.
Yeah.
And I agree that all the issues in all of Mr. Smith's cases now are revolve around this issue of getting information out of the organizations that are contracted by the city department. So
all right.
I agree with the motion to find a violation of 6725 for violating the timeliness, and I think we should keep the case open and get an opinion from our DCA after going back to DCA COLA's investigation of this to see what the status of these of COFAM and FAMSF, whatever, what the status is. And if they're not regulated under 12L, who are they regulated by?
So if you want to do that, let's just ask our DCA Wolf, can you provide us the time to be able to help the committee investigate this?
I think the first order should be to see what's already.
No, I'm saying including reading through some of that stuff and helping to advise them. Okay.
Great. Is there a second to that motion?
I'll second.
No, that was your,
I'll-
motion, I'll second it.
Can I just say, to be clear, if you guys can really detail, have a solid ask and what you want,
Can you make sense of it?
Member Cade?
Can I
Member Cade?
Can I give it a shot? I think the question that would be helpful to get an answer on is whether COFAM and the foundation are local agencies, and I'm trying to speak slowly for Cheryl. Would they constitute local agencies under Government Code 6252 and Government Code 54952? That's it.
Can I just, along the lines of what
No. There's...
No, this
You're
isn't to
allowed
the
to.
substance. It's to the point
Sure.
of,
Go ahead.
as there was a hearing last week that was referred to the task force back, as Mr. Kanata has stated, and to Mr. Smith's point, I would just ask in terms of the docketing of those, that this gets handed down before we come back in front of these very same people.
Absolutely.
In 30 days. I don't think
absolutely.
save all of
Agreed.
us.
That's why we want this.
Okay.
That's why we want
No, I
legal
just wanted to
opinion.
make that point to
Absolutely.
show, because I know she's going to be making the schedule.
Absolutely.
And it
Yeah.
all comes together.
Great.
No problem.
Thank you.
No problem.
All right. I don't see any members of the public at this point.
I would just add to Member Kate's point and just how it applies to the ordinance when the results of
sure.
that.
Right.
It's not just the ordinance, but CPRA
And that's
or the Brown
the
Act.
provision. Yeah, the government code sections.
Oh, that was for the CPRA?
That was for the
Okay.
CPRA, which I would think would then latch onto the ordinance. The ordinance issues with a 12L. I don't know if that would solve all the problems. I don't think, because my understanding of 12L has to do with basically requiring the disclosure of certain financial records.
It's a whole nother process.
Right.
I mean, your sunshine request goes to the contracting agency. They are the ones that communicate. You don't get to communicate directly with the nonprofit. If you want other documents that are not currently made public. And then if you're not happy with the answer that you get from the from the contracting agency, then you can come to the task force only for a hearing regarding the contracting agency's response.
I'm sorry.
So I had a follow-up question. Does anyone on the task force know whether we have any of the underlying documents that sort of describe or define each of these organizations, whether it's like an internal
I feel like
articles of
we do.
incorporation?
We do.
I mean, it'd be
Yeah.
really helpful.
Was in a previous case?
Remember, Rick Nee requested and received
right.
and submitted, so it should be in the record. And
Oh,
it was
wait,
sometime in the past, like 4 months.
Yeah, I can send that
And I
to
think
you.
these were
He
also
said-
provided
he
in front of
CC'd
the full time, but it's been a while.
To the extent Ms. Ledger can find that, that would be helpful.
Yeah, because I mean, I think, and I don't want to short circuit, but I mean, I do think probably in terms of whether, like, particularly these emails, for example, are going to have to be something that COFAM has to turn over. I think the quickest and shortest route is if COFAM were basically an agency to which the Public Records Act applies,
Right.
and thereby, of course, the ordinance. And I mean, under those two provisions, the one provision basically they link to each other, and the question winds up being about how are the organizations structured, and what kind of overlap is there between the city and the agency or the nonprofit. And I do feel like I thought we had the materials that would allow us to make that determination, but I can't remember, because I know there were some PowerPoints that. What's that? 18049.
So just as a random aside for Mr. Smith, if you look at the Form 990s for COFAM, you might find some interesting stuff.
I already have done that.
All right.
And the answer to your question is you do have the materials, because we've been through this exercise before, and you were given the materials about the connection between these organizations. They were provided by the museums and so on. You have the material.
Okay. Yeah. Can we vote?
All right, we ready for the roll? Go ahead.
Martin?
Aye.
Aye.
Thank you.
Member Tesfaye?
Aye.
Aye. Member LaHood?
Aye.
Member LaHood, aye. Member Kate? Member Kate, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Member Highland, absent. Member Bruce Wolf?
Aye.
Member Bruce, Chair Wolf?
Aye.
Chair Wolf, aye. The motion passes.
All right, great. Next item.
Item number 12, reports from Sunshine Ordinance Task Force committees.
Any, let's see, which committee should we start with? EOTC, have any reports?
EOT hasn't met since May.
I guess that would be a no. Compliance and amendments?
Yeah, just because we just heard this, the reason we sent back Mr. Smith's other case was for this exact reason. I mean, there were redactions and stuff, but it was still the fact of the separation, of the claim of separation of COFAM, and they don't have to comply. So getting a decision on this will resolve all three cases.
Great.
I have a question. Do you want compliance and amendments to follow this? Because we didn't actually formally refer it.
Yeah,
But
that's
if you
good.
want to, okay, you could just take it up yourself as a committee. Okay.
When we get some information
Okay.
back, we'll.
All right, so DCA Wolf, I would communicate with Member Kanata on any
Through Cheryl.
information.
All right. Rules Committee?
But I'm gone through October 17th, so.
Sure. We're having a meeting at the end of September, I believe the same day as after the CAC meeting. It will be on primarily the code of conduct and some other items. And I know that we talked about the full task force having notice of that hearing. So if you want to come, let Cheryl know so that we can ensure that we don't have a quorum. So.
For rules, isn't that you, Member Yankee, and Member Highland?
Yeah, but we were going to notify the task force in case other people wanted to
Okay.
come.
Yeah, the initial rules conversation got a little heated, so that was why we, or the code of conduct, I should say. The technology committee, I'm assuming, hasn't met. Complaints committee?
Complaints is fine. She'll set up the next one, I think September 17. And yeah, I think we heard 4 or 5 last week, and most of them, not all of them, are going up to the full task force at some point.
Is that the 17th?
Yeah. It's a Tuesday at 5:30.
Great, and I think that's all the committees. Am I missing one?
Mm-hmm. No, you're fine.
All right, next item.
Item number 13, Chair's report.
That's not me right now.
That's right. I don't have much to report. I'm very slow in getting the annual report out, which is now probably going to cover 3 years. But and the ones in the past have usually covered 2 years anyway. So, but just taking a look. If there are any, I think like this particular issue is something I'm going to include in the annual report that the Board of Supervisors should know about. And if there are any other particular issues like that.
Yeah, and the other thing that came up in compliance and amendments was Denta Tedessa again.
Yeah.
And,
right.
I'll
That's true.
I'll email you some.
One.
Okay. And I think
I'll
that-
email you offline about that. But,
Yes.
Okay.
Yeah.
Basically, the sheriff's department said they had this whole program, right? They were going to train everybody.
Yeah.
And, we have some of their documents, and then the representative of the sheriff's department said, oh, that was only a trial program. We're not going to go with it.
Pilot program.
So I think that the Friends of the Library is somehow vaguely parallel to the COFAM issue. I don't know how parallel, but
I was going to say, yeah, I agree with Josh. I think the Friends and what was shaping up with the zoo.
Yep.
And COFAM, where the public agencies are relinquishing essentially administrative function to a private entity through a MOU.
And feeling that they're not, that they don't
Right,
have to
and
be
they don't have to
responsive.
be, but I think the zoo won, the Friends of the Library and COFAM.
And on
that
a
almost feels like
smaller
it should be its
scale-
own report.
On a smaller scale, the thing with the Mission Dolores with the benefits district and how they hired an outside contractor, and so they didn't have control of the records. And we're just seeing this come up again and again.
Yeah, that one's dicier too, because they can claim that they're just a group of neighbors until the city actually designates them a benefits district.
Right.
It's different if the meetings are organized and run by a city department.
Well, that's
one-
the process.
Right.
The whole thing was, were they before the trigger or
Right,
after
right,
the
right,
trigger?
yeah,
Right.
yeah.
When does life begin?
Yeah.
Exactly.
I think those are both interesting issues that feel similar, but they're almost the inverse, because one is these actual entities, and the other is the lack of an actual entity.
Right, and it's also who gets money from the city and who gives money to the city.
Right.
Yeah.
Where were we?
And or if they are contracted, so getting money from the city, which part of the law applies versus giving money, which is another part of the law that applies, right?
Well, yeah, this is my whole argument against the fact that the ordinance means just 6729, because any department can go out and hire a third party and say, hey, we don't have any information.
This feels like the pitch meeting for the wonkiest magazine ever.
Well, you should read the board resolution from the Fine Arts Museum creating the memorandum. It's interesting. It's one page, but it's interesting.
Anything else for the chair's report?
No.
Great. Next item, please.
Item number, excuse me. Item number 14, staff report, complaints and communications.
Sorry, I'm just kind
Sure.
of trying to figure out where it would fall. Last meeting, member LaHood and I were supposed to, consult with our organizations about our support of using the changes that happened in the proposition, I think it was Prop B, in order to change the assignment of the seat. And I did do that, so if I just want to know when I need to report on that on the agenda.
Whether your organization agrees to it or not.
Or I just more so just how I would vote. I don't want to.
Right.
Yeah.
So should that be an agendized item is what you're asking for in a future meeting?
No, where on the agenda are we going to report on that today?
Do next. It could be the next.
Well,
item,
it would
couldn't
be good if you
'Cause
can
I thought
report
we
it today. That would be good because everybody's been waiting with bated breath.
Right. So
And
so I
they've-
just want to know when on the agenda that we can address
next.
that. Okay.
Announcements.
Right.
Very general. Okay.
Yeah, we can do that.
All right.
Great. So are you still doing the staff report?
We're just finishing chair report, and I've got nothing more to report.
We'd already moved to staff report.
Okay, staff report.
Okay. Tentative hearings scheduled for the remainder of 2019. As was pointed out at the last committee meeting, Sunshine Task Force meeting, November 26th is like the Tuesday before Thanksgiving. Am I correct on that?
So, yeah, let's
The
ask.
Thanksgiving
People
is the
gonna be here?
28th, I believe.
Yeah, I will be here. So I don't know about my other, for compliance and amendments
November
on
26th.
November
Well,
26th.
since my birthday's the day before it, I might be here physically.
Okay.
Okay, and then the following month, December 24th, is compliance and amendments again. That's the day before Christmas, so.
Yeah.
Will not
Anybody-
be here.
Anybody? You will or won't be?
No.
The room's,
No, will
the
not
building's
be.
Won't be
actually
here?
closed on
Christmas
Christmas Eve.
Yeah.
Not my department.
Do you want to, the question is will we have quorum? And if we won't have quorum, then the question is, should we move the meeting?
Well, first the question is whether the building's even open on Christmas Eve.
Well, my office is open until 5 o'clock, but
Yeah,
there's
the
sometimes
building may
people
close
here.
After the employees are gone.
Yeah,
I'd have to
I'll
find out about that
Well,
then.
again, besides that, will we have quorum? If we won't have quorum, there won't be a meeting, but that starts creating a backlog. So
When is that?
that's December
December
24th,
24th.
so
What?
they,
That's not a full meeting.
oh, that's compliance and
Compliance and
amendments.
amendments.
I'm sorry, yeah,
Compliance and amendments.
compliance and amendments. All right, well, that's up to you
To be
guys.
decided at the
Well,
next
we have
CAC
3
meeting?
other meetings before that one, so maybe we won't need it.
No, we're not, there's no way we're having a meeting on the 24th.
Okay,
Or you can have a meeting on the 24th.
I'm not gonna be here.
if you'd like.
and then let's scratch
All right,
that.
that's dead.
That settles
Dead.
that.
Next.
Okay. Great, and then, so then New Year's Day?
Canceled. It's
Yeah, and
canceled
potential rescheduled dates.
So those are the Mondays that we may have a room available to reschedule the task force for?
Those are Wednesdays?
Tuesdays, I believe.
Okay. Right. In place of those, right?
What would you like to do?
Well, complaints and amendments should meet in January, right? Because you won't meet in December. Okay, so shall we have our meeting on January 21st? Sounds good. All right,
And then again, a week later, 2 weeks later?
and then,
Before.
yeah,
We
then
did it
2
in
weeks later,
July.
yeah.
We didn't.
Then we back to regular schedule.
We got a complaint from 2016 on here.
Well, we got rid of a whole bunch of, we got rid of what?
We did.
15, 20 items today.
Before Cheryl goes on, can you tell me, I wasn't here at the beginning of the meeting, can you tell me what happened with the Tribos?
They were all closed, and so were the,
Randy Sinky?
Yeah.
Randy Sinky.
Okay,
Yeah,
those
I
are
s-
all closed, so
So I
there's,
spoke with Mr. Bowe yesterday, and she said she'd seen the agenda, and she wanted to know what the status was, and I told her, I said, well, the committee is moving to have your items closed due to inactivity, lack of communication, and a couple of other things. I
yeah,
had a-
did you
I
send,
a
did you
memo.
send her letter around to everybody? Yeah, you got it, okay. So,
I included everything, that
Yeah,
all the
okay.
correspondence that we had gotten.
that's fine. All right, so there's no more cases under
All her
that?
cases for 2019 have been withdrawn.
Have been
So
with-
all
okay.
those cases that were 2017, 2018 are now closed.
They're not closed.
She
So
knew
there's-
that was going to happen.
Are there any others floating around?
There are only Liz Arbus, Carlos Petri, the aliases.
Okay. All right, if you can agendize those for the next meeting, you know,
Mhm.
just clean up.
Clean up the
This is all
record.
cleanup, yeah. Okay, thanks.
All right.
All right, anything else on your report?
We got about, for April, I counted, we got about 7 new cases, a couple of which have already been withdrawn. Pending petitions and complaints. That's going to change next month with the closing of the Tribot files. So that's going to change to a much lower number.
All right, as much as you can, continue to agendize all those older
Yeah.
ones. Try to get us current.
Get us cleared out, okay.
Thanks.
Pending petitions, referrals from SOTF, the Tribot matters. As we spoke about Mr. Tedeschi's matters, we spoke about Mr. Smith's 2 matters. Let's see. 19017 is the ACLU. They wanted the white pages document. So for the next Compliance and Amendments Committee, we're going to see what the status of that is with the police department. 19048, the task force found that the zoo violated the administrative code and referred the matter to Compliance and Amendments. Do we hear that? Justin Barker?
That name does sound a little
Oh, wait,
familiar.
hold on. Compliance and amendments, wait, coming up or from the past meeting?
In the past.
What was the issue again?
He wanted animal records, animal medical
Yeah,
records.
yeah,
Yeah, from the zoo.
It's not,
Zoo.
the zoo,
And it's not come back, 'cause
yeah.
that was just
Yeah.
our last meeting that he was back again.
Okay.
And the zoo's gonna say no.
Well, they do have business and professions code that they can fall back on, so. The communications, I included those.
Hold on.
Oh, sorry.
Number 4, pending issues. So the first one, I'll get active on that one. The second one is the Mary Miles versus SFMTA. Those are three cases.
Those are on the agenda, I believe, for October.
Okay, did we get an opinion from our legal counsel on that?
Not yet. I will send them the information tomorrow.
Okay.
Something else I'm missing? Communications. We had spoken about Mr. Clark's record of telephone calls. He made a public comment about that. Why didn't the Arts Commission keep a record of telephone calls like the fire department or the police department has? When we discussed that at Peter Dolan regarding Board of Supervisors meeting, Lillian Steelstra. Lillian Steelstra provided a comment on green benefits districts after Mr. Sullivan's 2 matters. She made public comment, and then she continued that with a written statement. Ricky Wright, I don't know what to do with this person because I'm getting emails that have pictures and language that implies he wants to make a complaint against OnLock, but I don't think we have jurisdiction. So that's why I provided his emails.
Oh, did you send it to the complaint committee?
No, it hasn't gone yet.
Oh, okay. Let
It
them
just came-
determine jurisdiction.
Okay.
I mean, if you're unsure, I mean, I would send it to committee, and they have contracts with the city.
They're contracting with the city. A lot of their contracts.
Yeah, a lot of them.
actually.
So if you're unsure, I mean, you almost shouldn't make determinations of whether it's within our jurisdiction or not. We should be making those decisions.
Okay. I can open a complaint file.
Yeah, put them in the complaint file.
Okay. Let's see.
Did you make that? Did you suggest the correction when you approved the minutes for Rick Nee's proposed correction?
No, it's my fault. I forgot to mention this.
You have it? Because we can do that right now. What's 740? Oh.
Yeah, I know.
Oh, okay. So the amendment would be to strike the word, I don't know why I said, I have to reread that, but well, I'll take his word for it.
He said there's no minority group.
Yeah, to allow a member of the site. So it says that something I said, Chair Wolf stated that the task force agrees to have the Board of Supervisors amend the Sunshine Ordinance to allow a member from the Society of Professional Journalists in their minority group to become the nominating party for the minority seat. I don't know what it would be to change, what there would be just to strike it. I guess strike in their minority group.
I thought they were creating like a minority subgroup.
It was I mean, I don't know if we want to be in the habit of amending the minutes to change something that you
right.
said, but I think you would probably say on the second line here of the existing minute, right? Chair Wolf stated the task force agrees to have the board supervisors amend the Sunshine Ordinance to allow a minority member of the Society of Professional Journalists to become a nominee to fill the seat.
Right.
I don't even think it needs to be a member of SPJ. It just needs to be somebody
Freedom of
vetted
Information Committee will pick are we still using the word minority? Would pick a minority member, but it'd be the Freedom of Information Committee of SPJ picking someone who's a minority.
Oh, I thought it was a special minority committee.
Well, according to him, according to Rick, he says SPJ NorCal is no, quote, minority group, unquote. Should SPJ NorCal gain nominating authority, the chapter's Freedom of Information Committee would recruit and vet applicants for the task force minority journalist seat and would recommend a candidate to the chapter board of directors, which in turn submit the nomination to the board of supervisors.
And I agree with his language because the person does not have to be a member of SPJ. SPJ would be responsible for vetting candidates.
We wouldn't amend the minutes.
Right. I feel like this is an accurate representation of what you said, and if we changed it, then we don't want to do that.
That is what you said. I mean, it just wasn't correct as to what they wanted to do.
So don't amend, don't change it.
Change the minutes. You can add this.
Can we add that as attach it to the minutes?
Attach it to the minutes?
No, it has to be in.
Does it have to be in line?
Yeah, it has to be in the minutes.
No addendums.
Otherwise, Mr. Hartz will come and get us.
Yeah.
I mean, it's not a public comment.
It sort of
It
is
is a public comment.
Yeah.
It's
And it's
public
Rick.
communications.
I'm not sure Rick would care where it was in the agenda.
Yeah, we'll go. Yeah.
The minutes.
That's
The
what-
problem is if anybody looks at the minutes, and actually this was his point last time, they're not going to see this because they're not going to be looking for it.
It's not the same thing, because what he was doing was providing public comment at a meeting.
That was
This is a communication that was provided as part of the communications report.
I see what you're saying, yeah.
It's completely independent. I would just,
Can this be included in the minutes for this month, saying we received this
Instead of changing
and this
that
is
at all,
an update on the intent?
When we talk about it at
if
the
you,
next
you
agenda
can,
item.
look, you can amend the minutes any way you want, more or less, but the idea is, this came after the meeting on August 26th.
Right.
Okay, so, and the meeting was what, August 7th?
So we're discussing it today, and I would say that the second paragraph of this email is an accurate representation of how it would be handled.
And it's,
Should I?
And it's 9:17, so let's have a decision by 9:18.
But it's not what he
I like
said.
that. I like that.
It's not what he said, though. Is the thing.
Right. I'm not suggesting that we modify the August minutes. I'm saying that we include this in the September minutes.
Second.
Right.
Well,
It already is in the minutes. It's in the communication
All right.
section.
All right, we're done.
Next item.
it'll be there 4 different paragraphs.
Next item, please.
What page did you say it was on? Remember, Kate?
Or
Oh, it was 743.
143.
on there.
Yeah, okay, it's there. Almost.
Let's see.
Yeah, I need to bring a fan in.
Requests from community persons, we received a lot, and they're all listed.
Okay.
Next item.
Item number 15, announcements, comments, questions, and future agenda items by members of the Sunshine Ordinance Task Force.
Would we like to retake up the issue of if we will be supporting the change in the seat?
For a vote?
For a vote. Is that what we were doing last time?
I think we already took a vote on that, didn't we?
No.
Oh, we were waiting for you. That's right, we were waiting for you guys.
Both me and
Right, so
Lyle.
yes, we will
I
take.
think it would have.
Okay,
to
well,
be-
I am prepared to take a vote.
You are.
Take a vote if it's not on the
I
agenda.
think
We
it would have
can't
to
take
be
in a
the-
vote tonight. No, it needs to be agendized.
But we can have your input tonight.
Yeah, we can't amend an agenda for adding an action item.
Okay, well, then I guess it needs to be on the next agenda. I thought that we had agreed at the last meeting to have it agendized here, and I should have caught that.
That may have been, yeah, that was my oversight. Sorry about that.
So let's make sure there's an action item for that next month.
What is it again?
It was to approve the action, I guess.
To support.
To support the use of the Prop B Sunshine, the ability of the Board of Supervisors to amend the Sunshine Ordinance for the purposes of adjusting the minority seat. I can't say that. They call it the diversity seat.
Only for the purpose.
Only for the purpose, and only for this purpose, and for none other, that this section was meant for the purposes of the entirety of Prop B and Prop B only in its confinement, that we would allow just this one thing. I know, I'm telling you.
I won't be here to vote no.
All right. Next item.
That's the last item. Anybody else have announcements or anything they
Oh,
want
yeah.
to say?
Anybody else have announcements or, yeah, what you just said?
No, okay.
All right.
Last item.
Item 16, adjournment.
Yeah, so moved.
It is 9:21 and the
Thank
meeting's
you.
adjourned.
Oh, man.
Thank you.
So Bruce, the next complaint.